Division Bench Item 1, Review Petition 184/2019.
If you also can see order date is 13 last order. 13/11/4.
Who is for the other side?
Oh.
Nobody?
Payang.
Where is Mr. Paya? They have not filed any affidavit also.
Yes.
No, not filed.
Not filing. He asked for 4,000.
The last order is there, my lord. Without, if they fail to file affidavit, then that matter will be taken. But he is now.
Payang.
Hmm? Suspension online.
আমার সাসপেনশন করছে 5% দিতেছে সাসপেনশন করছে আমার একটা টাকা আছে
Heard Mr. H.R. Chaudhary, the Senior Counsel, assisted by Mr. A.M. Ahmed, Learned Counsel for the petitioner. Also heard Mr. G. For P. Sharma, an additional senior government advocate appearing for the respondent number. No, respondent number 3. No representation of any of the respondents. Mr. You see only that and leave it. Because we only read the names. We'll pass orders in the chambers.
Right.
You are only relying on Abdul Qudus.
Yes.
And who is the proceedee whose reference is answered in the affirmative?
Yes.
Proceedings,
Right.
what is the relationship?
All brothers, my sisters, sister.
Brothers and sisters?
Yes.
No, wife. 3 number to wife.
No. Oh, here my relation, the petitioner.
Petitioner and the proceedee who was declared to be Indian.
Yes, they are all family members, my brothers, sisters, paternal uncles, and they are my aunt. And
Brothers, sisters, paternal aunt.
paternal aunt, paternal uncle, paternal aunt. Same family members. Family.
Please show us those documents, pages.
And petition number 1, my lord, 1 and 3, 1 and 2. 1 and 2, that's the grade 4 regular employee, my lord.
No. The documents
Yes.
on which you are relying for showing the relationship,
My lord.
that opinion
Yes,
for other family members,
Yes.
which are those pages?
yes, those pages. You lost, yes, NRC. Huh? And that's the page photo one, huh? Yes, your loss will find from page 10.
1099.
It starts from 102, my.
Who is there in 102?
Yes, 102, your loss will find, name is Siraj Ali, our name, the present petitioner's name in the NRC. But because the case is pending, so they might find the final list, it has not come. 102. Other than the yes.
Baba.
Now, who is
Your loss will left side, my lord. Your loss will find late Abdul Aziz, father's name. And top your loss will find late Kaluha, grandfather's. Legacy, my lord, family tree. Your loss got it 102, my.
yes, sir. Who are these people at number 2, serial number 2?
Serial number 2, Chandrabano. That is other Abdul Majid, other member Abdul Majid. Abdul Majid, your loss will find 107. Kaluha, our uncle, my paternal uncle.
Page number?
Page number 107. Abdul Majid. Here also Abdul Majid name is there, my serial number 3, my paternal uncle,
107.
107 Abdul Majid.
And where have you introduced this Abdul Majid in your written statement?
Yes, your worship will find. Page 71.
Yes. We are there at page 71.
Yes. Your lordship, a copy of the NRC of 1951 have the
No,
names
no,
of it.
name, the particular name. We are just on the names on whom we are relying to say that they are your brother and sister.
Yes.
Is a statement made in the written statement.
Written statement, your lordship will find the opposite button number 1 begs to state that he is having the following documents in his favor to establish his legal right to live reside in India. You page 71. A copy of the NRC.
No, that is okay,
Yes.
but whether you have given the names,
Or in the next one. Next one.
because the issue is also
Yes.
that the NRC is only a draft.
No, now, of course, it has been, my lord, because
So
for the
it's still
71 or 51, that now ultimately, my lord, constitutional bench already declared that 71. So only declaration with the division bench that remains. Other things complete, my. Final
No.
list already out, but it was not notification not made because of
So
the
unless
tendency of
you
the
say-
case before the Supreme Court, my.
Still, if it is not notified, it is not notified.
Yes.
There can't be a
But all
presumption of.
procedure has been, my your lordship kindly, your lordship will find that all the procedures, the statutory rules, my lord.
No, but without notification, everything,
Notification
Please
for the
answer that.
once final 31st August 2019, the notification also made, my lord. Your lordship. This the procedure. Already there, my lord, but because of that constitution pending before the constitutional bench. Because whether if it is 51, naturally it cannot come into effect, my lord. It will be taken into consideration. So that's why, my lord, now constitutional bench has declared that yes, it will be 71. And constitutional bench also said, my lord, registry was directed to place before the Honorable Chief Justice to place it before the appropriate division bench, my. But that division is both the judges already retired, my. So new benches will constitute. Only declaration part remains, my. So far court is concerned. But officially it was already published. 31st August, my lord. 19. Personal official. Okay. Yes. You are also kindly see we are having this, that form. Data copy. You are also kindly see this, bottom, my lord, final list published, my publication final, see, 31st August 19. From the website we have published. From the- Right, sir.
ফাইনাল কোৱা নাই নাই এতিয়াও নটিফাই হোৱা নাই কিবা নটিফাই হোৱা নাই এতিয়া
Because of the tendency of the case.
first question is that this reference
My lord.
was of 2002. The
Yeah.
IMDT case, it's a
That was-
2001 reference.
in the Bonwal case, but it got transferred to FT.
Yes. So this is reference of 2001.
Yes,
As per this document you have produced,
yes. Started, preparation started long back, my. That's why
no,
our name is also there, my.
no, preparation started.
Yes. 27 February 15, my.
Yes, so this is after reference.
After reference. So 15, my lord,
No,
15.
we understand, but it's after reference, post reference. Post reference, it is your declaration which is being accepted.
My lord.
So how far that can override opinion of the tribunal? That is the second question.
No,
Because
that's my lord,
this,
so
they,
long,
because there are adjudications which say that it is only the opinion of the tribunal which will prevail, and it will override the NRC. So it's not otherwise that the administrative
It is
exercise of-
administrative, my lord. Your lordship, it is also statutory authority.
no, that's okay. But it doesn't override the tribunal's opinion.
No, man, because of Supreme Court's one Kudus order, my lord. If subsequently, the authority passes, then it will have to take it into consideration. That's why we are before the lordship.
That is which paragraph in Abdul Quddus?
27, 28. We have given page 12 in our petition, my. Your
Page 12,
12 of the my review petition.
page 12 is, I think there's a wrong typing, isn't it?
My 27 and
It's-
28.
It should be 27, 28 instead of 20, 23.
That's, it is our fault.
No, no, it will.
Ah. Oh, my, actually, we have given from this original one. In there, it is 27, 28, but in the reported case, it is so we have corrected it.
Send the pay.
27, 28.
Hmm. They'll give different types. They need their own paragraphs. That's fine.
Mr. Sharma, any legal point you want to urge? You have not filed an affidavit.
My lord, I'm sorry, my lord, in this case, my lord, I have sent the comment for filing an affidavit, my lord. It is, the instruction has not yet come, my lord.
It will never come.
It will come,
The
my lord.
instruction is based only on the Supreme Court judgment.
No, my lord, it
You
is,
can't create anything because this is pending since last 2019.
19. Is not correct.
And every time it is adjourned, and then the bench is not available, so it again gets adjourned.
can it be fixed, my lord, any other date? Last,
no,
sons-
every day
last,
we
sons, my
can't-
lord, if I,
No,
I'll
It's
not.
a, it's a special bench, we can't sit, we are closing it today.
If, my lord, the next time no affidavit is filed, we will argue.
No,
on
no,
merit,
no, no,
my
no,
lord.
no. That order is already passed. We can't, a review petition can't be adjourned like that. We're giving you sufficient time.
Yes,
Mr. Payang,
yes,
we'll have to have the same standard. If our
No,
if our opinion of 2019 is now, a writ petition is filed,
yes,
we don't give him an interim production right now
yes,
because they have delayed in approaching the court.
yes.
So here it is a 2019 matter. We have to apply the same parameter.
Actually, my lord,
If you don't file, you close, you miss the bus. Because every time we can't sit
your
over the
lordship-
same document.
then your lordship will admit the matter, my lord, let it fix for hearing, we'll argue. on merit.
We are hearing it. There's no question of fixing. We are hearing it right now.
You may make your submission now, Mr. Paya.
Yes, my lord,
I think you are
actually-
well aware of all the
No, my
facts.
lord,
everything.
I have missed it out, my lord. That is
No,
the
no, no.
problem.
We close it then.
That's why, my
We
lord.
take our own call.
Then, my lord, we'll
We may have some shortcomings, but still we'll decide.
No, my lord. My lord, the grounds before your lordship, what my lord, it's in your friend is arguing. There are, my lord, what they have. Page 18 is the ground of review. my lord.
Yes, yes. They have taken only 3
Yes,
grounds.
3 grounds. my lord.
Yes.
The first ground is that what in the instant case would have made. So minor discrepancies should be regarded. My lord, they have relied on the, my lord, the Sirajul Haq. That Sirajul Haq has said, my lord, the minor discrepancies may be ignored. But in the Sirajul Haq, if your lordship.
2019 5
Yes,
SST.
my lord. Then in that case, my lord, it was only the name, minor mistake of the, my lord, father's name, my lord, Kepatullah become Kematullah. That much only. Others, all other persons, my lord, the relatives, other persons in the voter list, all are, my lord, consistent. Only the name.
No, Mr. Payang, you see, the difficulty is that in the High Court in exercise of review jurisdiction
Yes,
will not give its opinion as to what is the right, what is wrong.
yes, madam.
The matter has to go back to the tribunal for a fresh appreciation on the basis of the new materials available on record and subject to the what you call the decision of the Supreme Court in this Abdul Quddus, because we can't have the adjudication here. We can't even make a observation that the name A does not match with B.
No, that is another issue, my lord, because in the initial, my lord, review, the Abdul Quddus was not there. That point is not there. That point is not there. That's why, my lord, as Abdul Quddus has come, last occasion, my lord, I have asked for, my lord, we have to clarify whether the NRC has been accepted or not, as on now.
There's your government notification being produced, because this can't be a matter of what you call more deliberations.
It is
Huh?
there, madam. I have given a copy.
You have given a copy. So this is your website saying that it's finally
No,
published.
it is published, my lord. It is published, but whether it has been accepted as on now or not,
That
because
we don't
it is,
know. You see,
it is,
can we think of a situation where there is an act which is notified, and after that you say that whether it has been accepted?
no,
It's
my lord,
a notification.
to finalize the, my lord, as per rule, this Registrar General of India has to accept
No,
it,
no,
and
no, no.
he have to publish this. my
Please see this last entry. It doesn't say anything else. It says notification.
No, it is the government of Assam, my lord. It is, in fact, my lord, what my submission will be, that is under the central government. My lord, the Registrar General of India is under central government. It is the central government who will have to accept it and finally publish it, my lord. It is not the state government. The state government has no authority, in fact. It is the NRC
So
coordinator.
how do you publish notification?
No, that's fine, my lord. My lord, what the final list is published, what is there in the NRC of 2019. Then, my lord, it is under the central government authority. If central government accept it, it will be accepted. If central government will not accept it, we have no authority, my lord. It is the Registrar General of India, central government, who will have to publish it, my lord, after finalizing. The rule says, my lord. Rule says central government, the Registrar General of India has to publish. It is the Registrar General, not by the state government, my lord. In fact, if your lordship knows it well, my lord, while preparing the NRC also, state government were not allowed to enter any way, my lord. It is the NRC coordinator and the central government and the, my lord, Registrar
Then
General.
please tell us. Please tell us, according to you, this notification at last line, this is published by the state government. No, last line of the first page.
Bottom.
According to you, the NRC publication,
The publication of final NRC, yes.
who has made it?
This is by the NRC, man. NRC authority.
This is by the NRC
Yes,
authority.
NRC is that
So
court.
then,
My lord, it has to be accepted. That's why, my lord, the rule says. 2003 rules, my lord, the
2000C 3
my lord, NRC, national
NRC.
registration of. There you go. And my lord, that pleading was not in the review petition. That's why, my lord,
Not here. This is under which act?
My lord, the,
It will be a schedule, my lord, 4A. In the act, rules, my lord,
the
citizenship
citizenship registration of
rules
citizens and issue of
2003.
national identity cards,
Citizenship.
2003. The
Hmm.
citizenship registration of citizens and issue of national identity cards, rules 2003.
It will be some of it. We can read it.
ডাঙৰ খন।
No, no, no. It is a list to list.
Page 122. It starts. It is 129.
For Assam, my lord, 4, capital A4, within bracket 4.
There's no 4 capital A in this book.
Schedule 4A.
Where's the schedule? This is a schedule?
Yes, my lord, there is a schedule, my lord.
Are we having the same book? Give us the page number.
No, 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 no.
Assam, what of it?
Let us say. And as per, my lord, rule 4A probably,
Yes,
on the basis of rule 4A4, the schedule is prepared, my lord.
this is only for the state of Assam. my lord.
State of special. If your lordship is getting, this book, it is your
Rules 2003.
street.
Assam.
If I may submit this book.
It is there, my lord, we have it.
Just give us this doc paper, the
Madam.
2 pages.
एक मिनट। open it.
দুটা কপি দিছে সেইটো দেন আপোন
এইটো নহয়
সেইটো ভাল কপিটো দিয়ক
দি দিলো তো, তুমি চিন্তা কৰা নেকি কি হৈ আছে ডিভিশন ৰেজিষ্টাৰ জেনেৰেল আৰু ইয়াতে NRC কোঅৰ্ডিনেটৰ Your lordship will from rule 2, my lord, starts. এটা কার কি পড়া না 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 এটা পাবলিশ হবে
আমার খবর হয়ে গেছে এটা করবে এটা করবে
Yes, sir. Like preliminary issue in the case, my lord, if your lordship has seen, your lordship, my lord, the schedule, the under rule 7, sub rule 7, my lord, in the schedule, your lordship will find. Yes, schedule 4, my lord, schedule of 4A.
Page 127.
7. The schedule in the schedule 4A47, that publication of supplementary list, my lord.
7 rule 7.
Yes, ma'am. The local registration of citizenship register shall after the disposal of the claim and objection under subparagraph 3 of the paragraph 6.
Just a moment. Page 132.
That is, my lord, after the publication of the first list, then, my lord, there were claim and objections. Then, my lord, this is supplementary additional list. Later on, this list is published. My lord. The local registration of citizenship register shall after the disposal of the claims and objection under subsection 3 of the paragraph 6, prepare and publish a supplementary list for inclusion or deletion of names as the case may be, and thereafter the Registrar General of Citizen Register shall publish the final National Register of Indian citizens at the state of Assam. The final has to be published by the Registrar General. And subsequently, my lord, why this is not happening, my lord? Because your lordship knows it well, my lord, aware about this. Thereafter, the appeal provision is there. My lord, we know, my lord, we know. In the state of Assam, the appeal provisions were there thereafter, because after the publication of this final registration, my lord, they had to issue the rejection slips as well, rejection slips. Then, my lord, there will be appellate provision. Within 3 months, there will be appeal in the Foreigners Tribunal. That is another tribunal for the purpose of, my lord, this NRC finalization. The tribunals, my lord, as your lordship already knows, my lord, this honorable court has selected a poll about 200 members for those tribunals. Due to this, my lord, stake, my lord, as it was not finalized and no rejection slips were issued. So my lord, the tribunals have been, though they were appointed, they have been terminated. No tribunals has been formed. So that stays, my lord, And at the final stage, my lord, it is still pending. Para 8, my lord, the appeal provision is there. And this, my lord, Abdul Quddus, this, in fact, Abdul Quddus was only for this para 8, my lord. Para 8 of the, my lord, this group. Their contention was, my lord, in that case, as your lordship has gone through already, my lord, some persons who have been declared foreigner by the foreigners tribunal, suppose this person, my lord, who have been declared foreigners tribunal, his name, because as he has been declared foreigner by foreigners tribunal, his name automatically will not come in the NRC. His name will not be included in the NRC automatically. Now they claim before the Honorable Apex Court, no, we may be given another chance to go for this, my lord, under this para 8 of this rule for appeal, appealing against the, my lord, rejection made by the, my lord, foreigners, but NRC coordinators. Then the Honorable Apex Court says, no, it will work, it will come as, my lord, the res judicata. So as in one, my lord, competent foreigners tribunal has already declared you a foreigner, so you cannot go for appeal against in the similar foreigners tribunal. That was the, my lord, principle laid down in this case. What is the principle of this case, my lord?
Where is that part of the finding?
My lord, in Abdul Quddus, my lord will find at para 24 to 1960.
So Payal, anything more you want to add?
My lord, as because my lord, the only issue, the coming to this point was my lord, the whether my lord, the review can be is maintainable on this my lord under para 28, 27 of the my lord this or as per the order of this honorable court, my lord, the honorable court of this my lord, 27, 28 of the honorable apex court order, my lord. Abdul Quddus. That was the point here, my lord. Otherwise, my lord, on merit, I will come. To that, my lord, if your lordship, for that, my lord, your lordship may also see para 21, my lord. Para 21, my lord, the situation, and 26, 27, 27, 28 may be read again, my lord. Referring, para 21, my lord, in the judgment. It is referring because the, my lord, entire process is described in the earlier, my lord, how the foreigners tribunal is functioned. Then referring to above name amendment provision, it is urged on behalf of the appellant that was their case, my lord. Then order of the foreigners tribunal is an executive order which renders an opinion thereof. Therefore, it cannot be equated with a judgment. Summary opinion of the foreigners tribunal, it is submitted, is not detailed order, and hence it is not a decision of the judgment or judgment. Based on the said submission, it is argued that the opinion formed by the foreigners tribunal is not an order of competent authority, for the purpose of subpara 2 to para 3 of the Schedule to 2003 rules. Further, the opinion formed by the Foreigners Tribunal being an executive order would not operate as res judicata. It is highlighted that in some cases, persons who have been declared to be a foreigner under the Foreigners Act have been included in the draft National Register of Citizenship of State of Assam, while in other siblings and close blood relations of such persons have been named in the draft National Register of Citizens. It is averred that in these cases of contradiction, an aggrieved person should be entitled to take recourse of para 8 of the Schedule to 2003. That was their claim. Para 22 say, we have examined the contents of the no hesitation to holding that they have no force. This has been denied. The Foreigners Tribunal Act of the Citizenship Act, including the rules framed under the two acts, have to be read harmoniously as both the acts are interrelated and sister enactment. Then, my lord, it is discussed. Then para 24, my lord, it is under the jurisdiction, they have every right. Then your lordship may see only my lord, they are relying the para 28 now. The contention is the para 28, my lord. Quoted, my lord, your lordship may see from the para 26 onwards. When we apply general principle, para 27, as stated, a person aggrieved by the opinion or order of the tribunal can challenge the finding opinion expressed by way of writ petition, which they have already availed. By way of writ petition, they approach the Honorable Court, wherein the High Court would be entitled to examine the issue with reference to the evidence and material in the exercise of the power of judicial review, premised on the principle of error in decision-making process, etc. They serve as a necessary check to correct and rectify an error in the orders passed by the tribunal. So they have availed this jurisdiction, my lord. Then 28, my lord. It was highlighted that there could be contradiction decisions, opinions of Foreigners Tribunal, even in cases of near family members. That is the issue, my lord. Albeit contradictions can be avoided when family tree hearings are held as is now being undertaken. In the absence of joint decision, conflict is possible as the principle of res judicata would not apply to separate proceeding, even if against two closely related different persons. As each case has to be strictly decided on the fact and evidence on record. Secondly, there is possibility that, my lord, this may also possible, my lord. Someone of the near family members may have migrated to India prior to midnight of 24/3/1971. It should have been 71, and therefore fell in the different category. Any such conflict, however, would not compel us to take different view in terms of the clear statutory provision. My lord, here, if the petitioner claims, my lord, in fact, my lord, I'm not a in fact, suppose a person who has been declared foreigner, he claims that I'm the brother of my lord so and so. The brother may come earlier to 25/3/1971. The sister or the smaller other one may come after 25/3/71. This may also occur, my lord. In such situation, my lord, it will be different, and therefore fell in different category. Any such conflict, however, would not compel us to take different view in terms of the clear statutory provision. In a given case, my lord, the person aggrieved would have liberty to invoke res jurisdiction, which they have already invoked, my lord. Or if necessary, this is the point, my lord, they are taking. On this point, they are coming, or if necessary, review jurisdiction before the High Court or the court to ensure that no injustice is done. On this point, my lord, senior friend is arguing that, my lord, we may be given the review may be allowed only on this ground. The factual aspect in this case, my lord, in fact, the Honorable Apex Court has clearly said it may be different in different my lord, cases. And what my last submission was that day, my lord, because they are claiming that, my lord, some brothers and some others, family members' name have been enrolled and listed in the, my lord, the NRC. So they may be given opportunity to, they may be, my lord, allowed to, the review petition may be allowed. My contention was, my lord, last day, that because the NRC, my lord, that NRC, that NRC is not yet finalized because it is not published by the Registrar General of India as on now, my lord. Unless
Yes, Mr. Payam, what you
Yes.
saying?
my lord, that what my last submission was that, my lord, the NRC, which they are relying now, saying that as the NRC is published, where our other family members' name have been enrolled. So we may be given benefit of that NRC as per this judgment, my lord. So my contention was that, my lord, that NRC, my lord, which they are relying, not yet finalized, not yet accepted by the Registrar General as on now. It is not yet published by the Registrar General under, my lord, para 7 of the, my lord, 4, rule 4. So that documents as on now has, my lord, not valid documents. So if it is published by the, my lord, Registrar General, then, my lord, this at least, my lord, then we may look into it whether it is, my lord, on the basis of that documents they can be, my lord, the review can be accepted or not. Review can be, my lord, whether they are actually relative. On merit we can go on that. Then we could go for merit, my lord. The preliminary question is whether, my lord, as it is not yet finalized, it is not yet, my lord, valid document as on now. So, my lord, for the time being, it is premature. That was my submission, in fact, last occasion, for the purpose of, my lord, under this para 20 rule, para 28 of this judgment, my lord. Because if they want to get the benefit of this para 28 of this judgment, they will have to wait for some days to publish the NRC, my lord. Then they may come. If, my lord, then if they succeed, yes, my lord, the new evidence, this may be evidence for the purpose of the petitioner. Then, my lord, we can go for review. We can go for it. That was my argument, my lord.
Anything in reply?
Yes, ma'am.
My lord, I have said, otherwise, my lord, if your lordship here on merit, we'll argue on merit. That is, there on the review.
No, my learned friend, only
No,
question.
we are hearing on merit.
Yes.
This much of time we would not have spent for preliminaries.
And second, my lord, the grounds of review.
Third is the one again.
Huh?
Second, we have third is the one again.
Yes, my lord, the second, my lord, this is my preliminary objection on that, my lord, on this point. And secondly, my lord, the grounds of review, the judgment of the Honorable Court is for, my lord, review before this. And review jurisdiction, my lord, under review jurisdiction, as your lordship already, there are numbers of judgment, your lordship also knows. Only on 3 grounds review can be, my lord, accepted. Who is error apparent on the face of the record? There is no error apparent in the judgment of this Honorable Court. They have not pointed out whether the my lord, for that, my lord, your lordship may, I'm referring this judgment of 2013 8SCC, my lord, 320. 2013 8SCC 320. Kamalesh Verma, my lord.
Paragraph?
Para, my lord, in fact, 20.2. Para 20, my lord. 20 and 20.1 and 20.2, my lord. Under what condition review can be accepted? And when review is not maintainable, my lord. This details given, my lord. Uh, you know, they are relying, my lord, their second point was that 1966 voter list was not considered. My lord, it is, if it is, though it is considered, my lord, 66 is considered.
2013 8 SCC 320. Paragraph 20.
Yes. 20, 20.1, 20.2. In fact, my lord, this judgment has discussed almost all the judgments of earlier judgments of Honorable Apex Court. And each and every case.
Yes.
Let me kindly see. 20.1, my lord. When the review is maintainable, that is, my lord, that is universal, we know, my lord, as your lordship, discovery of new or important matter or evidence which after the exercise of due diligence was not within the knowledge of the petitioner or could not produce by him. Mistake or error apparent on the face of the record, any other sufficient reasons. Then, my lord, paragraph 20.2, when the review will not be maintainable, this part, your lordship. A repetition of all or overall argument is not enough to repetition. Reopen conclusive adjudication, minor mistake of inconsequent import. Review proceeding cannot be equated with the original hearing of the case. Review is not maintainable unless the material error manifests on the face of the order, undermine its soundness, or results in the miscarriage of justice. Well,
But still, you see, the Supreme Court was aware
Yes.
when this Abdul Quddus was being authored and delivered about this Kamlesh Verma, they were aware of it.
yes,
But
my lord.
still, it says that NRC, if it is there, if that adjudicated process is there, it can still be a ground of petition or review.
My lord, I understood, my lord. I'm not on that, my lord. My lord, my lord, what they're claiming is, my lord, they only claiming is that their second point of review. In the review, my lord, the only three grounds, my lord. First grounds is 60, my lord, the Abdul Quddus. The Abdul Quddus, my lord, as I have already pointed out. And secondly, my lord, even though Abdul Quddus comes, my lord, the next point is to be seen whether, my lord, the brothers or sisters, whose siblings, whose names are appearing in the NRC, why they were not brought, my lord. It is not that, my lord, they did not know anything about these brothers. These are the knowledge which were there with the petitioner prior to the, my lord, passing of the judgment. These are not new knowledge, my lord. These are not new knowledge which they have gathered after the, my lord, opinion or judgment is passed by the Honorable Court. It is their duty, if they did not plead that my brother is so and so, my sister is so and so, I have this brother, my lord, if they do not plead in the, my lord, their written statement or evidence, or in the, my lord, the writ jurisdiction, it is not the fault of the court or the, my lord, state. They are now coming and saying, my lord, that our siblings' names are there in the NRC. Why they did not come before the tribunal, my lord, prior to that? This is not a new fact or new, my lord, discovery. And second point, they argue their ground is, my lord, 1970s and 66 footer list of petitioner number 3. And it is father of Abdul Rashid, petitioner number 3. Well, that is inconsequence. That there is no consequence. 66, 70, even to accept it, 66, 70 voter list, it is there. But it is their duty to connect them along with 66 and 70 voter list. They fail to connect that. Even, my lord, though it is accepted or denied. And that's why, my lord, the Honorable Apex Court in that this judgment has said. the my lord, review is not maintainable unless the material error. What is the material error, my lord? Manifest on the face of the order, undermine the soundness of result of the miscarriage of justice. My lord, if your lordship see the judgment, my lord, judgment, it has discussed everything about the my lord for a tribunal. What tribunal has discussed, wholly of my lord, everything has been considered. And if 66 and 71 is accepted also, then also they fail to connect the my lord 66, 71 voter list, the petitioners. That's why, my lord, even though it is accepted or denied, then also it will not give any my lord, fruitful result to them, because even if it is accepted, they have to connect them somehow. Miscarriage of justice. And it will not, a review is by no means an appeal in discuss. But in fact, it will be an appeal if they go for. If they prefer an appeal before the Honorable Apex Court, that is better, because review is not it is in the form of appeal, man. Mere possibility of two views on the subject cannot be a ground of review. My lord, the error apparent on the face of the record should not be an error which has to be fished out or searched. My lord, what my submission is, where is the error? They have not pointed out where is direct error. We have to, so all these grounds doesn't, in any of these ground, my lord, this review is not maintained. And third ground is, their ground is that petitioner number 1 and 2 are regular grade 4 employee of PWD and Legal Metrology Department of Assam, and their appointments were made after police verification, which was not. These were, my lord, facts which were known to them. They pleaded it. They, my lord, these were taken considered. If they are not satisfied with the, my lord, consideration of this honorable court, they very well they can go for appeal, my lord. So review is not maintainable in this format. That is.
Completely nago kowa.
আপনি কখনো যদি আপনার প্রতিবাদ
My line is really taking time to review. We have not come from CPC or otherwise. We have come right from the Supreme Court order. This is my case. The second thing, my lord, what he is saying, that NRC so far is, he says if it is final, we have a case. That is what he is saying. My lord, this was published in terms of Supreme Court order, my lord. Supreme Court has given some schedule, my lord. You have to dispose the claim and objection within such date, then you have to publish such date. And that's why it was published on 31st. It is final. One day they are not giving rejection slip because of that question 5171. Once rejection slip come, then rule clause 8 will come, appeal will come. Rejection slip. Without giving, because that is final. After final, my rules, clause 8 has not been yet commenced. Court clause 8 will come, appeal, my lord, only when they will get the rejection slip. Rejection is not given because the Supreme Court is still, it is going on in Supreme Court. And the honorable, my lord, constitutional bench already given order, my lord, that is the formality is to be maintained that much, my lord. So it is final, my lord. My humble, it is final. Second thing is, my lord, it is a statutory authority. They have gone through all the procedures, my lord. Here in a tribunal, my lord, only, my lord, two modes of reference, my lord. One mode is by the police, other mode is from the debutters, my lord. Either from debutters tribunal will refer, or police on its own, my lord, they will make some inquiry. In the inquiry, your lordship also found. Person is not there present, but they are shown that he is present. He is somewhere in Jammu Kashmir, even we find, my lord, that said that I have gone to his house, he was not found. So that is, my lord, that is simple, my lord, reference. Tribunal is gives to opinion, not a final order, my lord. There to be opinion whether the person is a foreigner or not. That opinion is to given the Supreme Court, my lord. Now, Ministry of Home Affairs, my lord, we are not, that we got this now, just mobile, my lord. Ministry of Home Affairs say that this NRC is published in view of the order of the Honorable Supreme Court. That was a copy, we may give my copy to, it is there, my lord. So that is also, they have also, they published, they are saying it is published, my lord. If you also permit me, I'm sorry, my lord, just now. The Ministry of Home Affairs has revealed that supplementary list of, that is clause 7, my lord. Supplementary list of the inclusion and exclusion for the National Register, Assam was published on August 31st in accordance with the direction of the Director of the Supreme Court. So my lord, that is final, my lord, for this whole final. Now, once it is final and they have gone through all the stages, if you are kindly see from starting from clause 3, my lord, of the schedule 4A, my lord. They have gone, my lord, schedule 3, my lord, from the clause 2, my lord. Manner of preparation, then scrutiny of application, then my lord, publication of consolidated list, then locally again, then again additional list, then again claims and objection, thereafter again verification, then final list comes. So after having undertaken all the procedures, my lord, tribunal is not only relying on the police report, my lord, and which all the most of the time we find, my lord, that is not proper. This is my humble. And the appointment may after police verification, my lord. A person is appointed by the government service, my lord. He is a regular employee, my lord. Both petition number 1 and 2, my lord. Grade 4 employee, of course, my lord. So after police verification, the appointment was made. Nobody has objected to. That's all, my lord. Tribunal also may now decide about it in terms of this. That's all it can be done, my lord. Matter may be remanded to the tribunal will see, my lord. That way also it can be done. That's my lord. One person is getting salary, my lord, one is not suspension, he is not getting anything. Petition number 1.
This covers both the matters.
My lord? Yes.
This covers both these matters.
Yes.
Item
No, no,
Huh?
one only.
Oh, other matter I don't
No,
know.
no, no, only one matter.
I'm only one matter, my lord.
Item one, serious.
Item 1.
oh, acha, the writ petition file is there.
Yes.
Okay, okay,
Ah.
okay, okay.
My lord, only one point as my learned senior friend has says, the Home Department has, your lordship, as I have already read, the only point was that, my lord, it is in para 7, it is clearly said.
Yes, I
My
have
lord,
seen.
after, obviously verifications were done, my lord. After the local verification, registered citizenship sale, after
was
the
done, my
disposal
lord.
of claims and objection, under, there are 2 publications, my lord, under this rule 7, my lord, para 7, there are 2
So what is the
publications.
direction of the Supreme Court? Please find out that. You can
Yes.
give it to the court master.
Yes,
But that will prevail. If
Yes.
there is an order of the Supreme Court
No,
to
my
have
lord,
this published.
Supreme Court has direction for publish, my lord. Probably, I don't know what is there, whether it is there or
the
not.
Ministry of Home says.
Prepare and publish, my lord. That's why, my lord. Prepare and publish a supplementary list for inclusion and deletion of names. That is by the, my lord, as the case may be, and thereafter. That is to be published by the, my lord, NRC coordinator, not by the Registrar General.
We
First.
don't know.
That is,
If
that,
there's an order of the Supreme Court, that will override.
We also time, we will also time.
I don't know, my lord, whether there is direction. But,
No,
lord,
it is
but-
there,
You
madam.
see,
It is-
Mr. Chaudhary is showing to you the statement of the
Yes,
minister.
yes.
no,
If you
that's what, my
contact
lord.
him, nothing.
That is registration, registered by the melody. That is by the objection, my lord, the local registration of register cell. The local, my lord, NRC coordinator will publish first. That publication is done. I accept, my lord. But it has to be republished again after
Republish-
submission to the, my lord, Registrar General. It has to be published by the Registrar General.
Okay.
That will be final.
Okay.
That is not done. My lord, it can be cleared by the central government also, if your lordship, whether it is published
We'll
or not.
get it.
It is not
And
yet
directives
published.
to deliver, we will also try to give. madam.
Yes.
So more directives.
We also have a very reliable coordinator. He'll find it out.
In fact, my lord, everybody is demanding for
Cases.
publication of this, my lord, final register. Everybody is demanding. Otherwise, in fact, my learned senior was also one of the part, my lord, counterpart, demanding that final, this may be finalized and published, my lord.
সব কেস বলো So it is closed, my lord, arguments obliged to.
Password for the day is platform. Also as a representative.
Obliged. Lordship, item number 14.
Can it be possible for the day, Lordship? I could not get preparation today.
Okay, same order, 14.
May I please, Your Honor, sir, I need to mention item number 17, Lordship. I have taken from the consent from the opposite party, Lordship, and yesterday I have filed adjournment.
Yes, yes, there's an adjournment slip.
Can it
Okay.
be fixed after 2 weeks, Lordship?
After,
After 2 weeks, Lordship.
after 2 weeks.
Lordship.
Now, after 2 weeks will be very inconvenient because it will be last week,
After
Uh,
vacation, Lordship.
after vacation.
Obliged.
List in the first week of January 2025 as paid for by Land Council for the petitioner, appellant. You
Obliged.
say both sides are represented. Okay.
May I please, Lordship? Lordship, I beg to mention item number 12, Lordship. Lordship, senior counsel Disoma is not well, Lordship. Kindly make me come up next week, Lordship, any date. Item number 12, Lordship. Senior and Disoma is not well today, Lordship.
Okay, after a week, in next week, pass over the date, huh? Okay,
Lordship.
May I please, Your Lordship, I beg to mention item number 6 and 7, Lordship. And adjournment.
Oh,
for
that
the-
wholesale adjournment cannot be allowed. We are keeping
My
few matters in
some
the,
Personal difficult, that's why, Lordship.
then why don't you circulate a slip in ahead? We could have listed more cases. Now, you see, only about 10 cases are left out. All are adjourned.
Lordship, currently, my senior is out of the station for some personal difficulties. That's why I'm praying for adjournment for the day only.
But you see, you could have told us yesterday. What is this great difficulty in telling us? You get causes 2 days in advance. We are doing everything for you. But you don't tell us. If all the cases are adjourned, why we are sitting, 2 judges are, the time is being wasted.
But when for the day,
I mean, 2018, you don't want to do. 1 or 2 cases we are liberal, but if it comes to a wholesale adjournment in 2018 matters, you give a notice to your client and tell us that at your request, you have taken an adjournment, you inform your client and tell us. Otherwise, we'll impose 5,000 cost on the lawyer. As,
And the
as a
for
prayer
the
for
day, Lord.
adjournment in 2018 matter is made, the Land Council for the petitioner is directed to inform the petitioner about the adjournment taken, failing which the court may impose cost on the Land Council for the petitioner for adjournment, which will be, for which orders will be passed on the next date. List after the ensuing winter vacation. So you give a notice and then come. Item number
6 and 7, Lordship.
6 and 7.
Right.
In both the cases, you give notice and then come.
Please, your lordship, I beg to mention item number 10 due to some personal difficulty. on
No,
my
same,
end.
same order. You give notice to your client and then come, failing which will impose cost. That will be decided on the next date. Same order. Item number
10.
10. You give notice to your client and then come. These Tuesdays and Thursdays, we are listing less matters. If any adjournments are taken, we'll pass the same order. You will have to inform your client that you are taking adjournment. And Mr. Sharma, please remember it and remind us.
Yes, Lord.
This has to end. We are listing few matters in the cause list on these 2 days. The entire effort is lost. Yes,
Supplementary item 18 or motion.
Mr. Mathur, this is
I'm
unfortunate.
through it, my lord, very pathetic, my lord. In this
Uh-huh.
regard, my lord, I just wanted one judgment of the latest judgment passed by the Justice Chandrasu. That is, my lord, 2024 6 SCC 327.
Just a moment, Mr. 2024,
2024 6 SCC 327.
just a moment. What does it say, Mr. Monto?
My lord, Similar here also, my lord, 14-year-old girl, that Bombay High Court rejected her termination, then went to the Supreme Court. Supreme Court says that yes, with the medical board you can do it, but the consent of the girl victim is very important. So
In this case, we have taken that consent.
yes, ma'am. Yes, here in this case, guidelines is there, a consent is there. That's why, my lord, there, your lordship kindly see the para. That's why that context I am submitting, my lord.
Okay.
Para
okay.
36 is very important.
36.
Para 36.
Okay.
I think I for your lordship.
It's okay. We have this.
Yeah. Para 36.
Yes. Okay.
So para 9 of page 9 of the, my lord, paper book, I have seen that consent is given by the very clear terms. So in
Yes.
that case, my lord,
There's only
Medical
one. There's only one. The victim is ready, but the
Family is also ready.
father says that only it should be
safe.
Oh,
Yes,
safe.
Yes.
in that much. We will have a medical opinion of the board.
Exactly, man. That is very.
Mr. Ma'am, since I don't know the situation there of medical facilities prevailing there. Now, the option of the state would be either to take her to the Tinsukia Civil Hospital or to Dibrugarh Medical College and Hospital.
I spoke to the chairperson of the Child Welfare Committee of Tinsukia. They said that they have a board, and the Joint Director of Health Services is the chairperson of that board, and that board is available. They can do that, but now the pregnancy is over 24 weeks. So the order of the Honorable Court is required. And
Yes,
they,
yes.
they will do it. They will do that. And they said that the members are at different places. They need 3 days time just to
Okay. So Monday,
Monday.
you can produce it on Monday.
Time is very precious for this.
Lordship may direct fix the matter on Monday, and by that time they will sit and they will.
Because today is Thursday,
Yeah.
Friday, Saturday, and 3 days time they are having.
But
Monday.
they have said that as per procedure, the papers will, whatever documents already we have, or Lordship, I'll collect it. Everything, the chairperson will request the board, then board members, they will sit, and then thereafter they will start the examination of all these things.
Okay.
That will be expedite.
Okay,
Lordship,
we'll make that observation in the order.
Lordship. The committee,
What is that authority called?
the
District?
the chairman, Child Welfare Committee, I spoke to him, and that committee is as per section 4 of the Medical Termination of Pregnancy Act, that section 4, the clause B, Lordship has seen. There is a district level committee headed by the chief medical officer or the district health officer. He is there.
Medical termination frequency and medical termination frequency.
B, no?
4B. 4B. Small b, 4 small b.
No, 4B is the place.
Well,
The,
I'll just,
the
I'll,
board,
I'll read. A place for the time being approved for the purpose of this act by the government or a district level committee constituted by that government with the chief medical officer or district health officer as the chairperson of the said committee, provided that the district medical committee shall consist of not less than 3 or not more than 5 members. I'm indicating this committee, well, this
Okay,
committee is
okay,
there.
okay.
This committee is there.
okay.
No, medical board, that is my lord, actually in 2021, that is amended. And this is amended one is there.
Okay, please pass it on.
So তুমি হেয়ার কথা কৈছে তো নাই medical board কৰিব লাগিব but that is amended in 2021.
Amendment,
You don't have printer.
section 4 to amendment 1,
কিবা এটা section দেখিলো নেকি? সেটা বেছি।
21%, section 3 amendments.
Item 9.1.
কোন থাকিব কৈছে? 5.
অলমোস্ট ঠিকই আছে। হ্যাঁ, gynecology, radiology।
In 2021 amendment, section 3, amendment to section 3, below, kindly see 2C, below, 2C and 2D,
Yes, you see that.
2C and 2D. This is the committee, below. This is the board.
Just see the order and then
Well,
if something is to be added, please
Lodgement.
tell us.
Lodgement.
Heard. Mr. T.J. Mahanta. Learned Senior Counsel, assisted by Miss D. P. Sharma, Learned Counsel. Also heard Mr. D. Nath, Learned Senior Government Advocate, appearing for the respondents. Next para. From a news article appearing in the 29/11/2024 edition of the Times of India, it came to the notice that a minor girl was allegedly gang raped by 7 people, including 4 minors, at a location in the district of Tinsukia. And as per the newspaper reports, the girl was then 23 weeks pregnant. Full stop. Next paragraph. In view of the minority of the victim, an apprehension is expressed that the pregnancy could lead to substantial risk to the life of the victim as well as the unborn child, oblique fetus. Full stop. taking note of the next para, taking note of the provisions of section 3 and 4 of the Medical Termination of Pregnancy Act, 1971, and in light of the decision of the Supreme Court of India in the case of just open that judgment again. Damien,
Name always, no, name. Mr. X, change,
just open that judgment.
2024.
Mr. Lushai. Judgment. A versus State of Maharashtra, comma, within bracket 2024, bracket goes 6 SCC 327, comma, B. A direction was issued by this court to the Secretary, comma, District Legal Services Authority, comma, Tinsukia, within bracket DLSA, comma, Tinsukia. Here it goes. That through a lady paralegal volunteer, the house of the victim should be visited to ascertain if the minor victim girl or the parents of the guardian of the victim girl are interested to undergo a medical termination of unwanted pregnancy and to submit a report. Full stop. Pursuant to these said directions, comma, lady paralegal volunteer and other staff members of the Secretary, comma, DLSA, comma, Tinsukia had visited the house of the victim and recorded the statement of the parents of the victim. Full stop. However, as the victim was shifted to a certain shelter home, comma, on the next day, just at the statements recorded on 3/12/2024. And as she was shifted to a particular shelter home, comma, in the morning of 4/12/2024, comma, the said paralegal volunteer, along with the secretary and other staff members of the DLSA, comma, Tinsukia, visited the said shelter home and met the victim girl, and her statement was recorded. Full stop. Next para. From those statements, it is clear that both the victim as well as her parents want to terminate the unwanted pregnancy, despite being made aware about the risk involved. Most of the anxiety expressed by the parents of the victim is that they wanted the termination of pregnancy if it was possible to perform the same in a safe manner. Full stop. Next para. The ancillary information received through the DLSA is to the effect that pursuant to the report of the Secretary, comma, DLSA, comma, a police case has been registered under section 376 capital DA oblique 506 IPC read with Section 6 of the POCSO Act. Full stop. It may be mentioned that the particulars of the victim girl, her parents, and the police case, as well as the location where the victim is presently lodged, are not disclosed to maintain a privacy and to avoid any premature disclosure in public domain. Of these details in public domain. Next para. On the strength of the report submitted by the secretary, DLSA, Tinsukia, this Sumoto writ petition was preferred and accordingly the matters listed today. Next para. After deliberation on the procedures and modalities as prescribed under the Medical Termination of Pregnancy Act, 1971, as amended by the Medical Termination of Pregnancy within bracket amendment, bracket close Act, 2021. It appears that the relevant provision of section 2 within bracket capital C, 2 within bracket capital D, no, not capital, 2C and 2D, no dash, no bracket. And section 4. I'm sorry, it will be 3 within bracket 2C, 3, 2D, and section 4 are required to be followed. Next one. Accordingly, at the first stage, medical board, as provided under section 3 within bracket 2D, as well as the district level committee, in terms of the proviso to section 4 of the Medical Termination of Pregnancy Act, 1971, including the chairman, Child Welfare Committee of Tinsukia District, are required to examine required to have the victim examined by the medical board and to report as to whether it would be appropriate to have the unwanted pregnancy terminated. With special emphasis as to the risk involved in such a procedure. Full stop. Having noted the length of pregnancy as reported, the court is of the considered opinion that such examination, such medical examination of the victim be done as expeditiously as possible. Full stop. The next full stop, continue. At this stage, the learned senior government advocate has submitted that he will uh, that while interacting with the concerned authorities, he will give emphasis for an early examination of the victim girl. Next paragraph. Under the circumstances in which this order is being passed, the court is of the considered opinion that 3 days time from today be given to the state to comply with the requirement of the Medical Termination of Pregnancy Act, 1971, and rules framed thereunder, so as to examine have the victim girl medically examined. To the medical board as prescribed under section 3 within bracket 2, capital 2D of the said act, and submit a report to this court for the office of the senior government advocate. Next paragraph. The registry shall provide a copy of this suo motu rate petition with all annexures to the senior government advocate, so as to enable a physical copy as well as scanned copy by scanned copy in PDF format, so as to enable the learned senior government advocate to expeditiously transmit a copy of this order as well as the copy of the rate petition to the concerned authorities to do the needful. Next paragraph, the concerned authorities shall rely on the downloaded copy of this order as sent by the learned senior government advocate to do the needful, as supplying of the certified copy of the order will cause further delay in such transmission. Next paragraph, list on Monday, 9/12/2024. We are returning to this, we are getting copies. This is incorporated in the new book.
Yes.
It is already incorporated in
yeah,
new book.
yes.
But
Yes,
but
I
thank
will-
you. In this case, I'll thank both of you.
Actually, my lord, yesterday, my lord, well, very lately it was.
No,
provided to
everything
us.
happened in such a.
Yes, yes, because time is very precious in this case.
So therefore, we had the registrar to do extra work
That's why, my lord,
to
today.
have this done. In fact, I saw this news item on Sunday.
My lord.
I was out of station after returning. When I saw the newspaper, I saw this news item in the newspaper. And then I referred it to the registry, and then suddenly everything happened in 2 or
Right.
3 days.
We'll try on this.
Because
How long?
there's also a lack of experience in dealing in this matter, so it took at least some time to understand the gravity and then
Correct.
proceed. The need of the need of the hour and then to proceed. It took some time. Since this is not normally
No, yeah.
visited, this act is normally not visited, so I was not aware of these things.
Very true.
I'll see that the
Fine.
things are given to you by
Lot,
sometime.
lot. How long?
Not required. We have it in the book.
Item 19, motion.
May please, your lordship. My lord, even this case, my lord, earlier record was called for. Record is available.
Yes.
No interim, my lord, is given at that time, my lord. Here, my lord, this is the
We were
second,
not convinced with the delay, explanation of delay.
my lord, actually, my lord, we come in a second round of litigation, my lord, against the order dated 31/10/2022, page 60, my lord.
16,
60.
60.
My lord, in the first round, this honorable court has remanded the matter to the tribunal directing to pass a fresh order. The tribunal in the earlier order told the brother who was examined as DW2 as a stranger, because the WS is very casual, my lord. The about brother, there was no mention in the WS. But during my lord, cross-examination, the tribunal made query about the family, and she has stated clearly that they are my brothers. So mention has been made about brothers in the cross-examination. But the tribunal did not accept it because there is no mention in the WS. That was this part has been considered by this honorable court, and
Because now
directed to-
in the fresh opinion also,
same thing, my lord.
same thing, DW2 did not mention about this Haider as his brother.
Yes, my lord.
Then
My lord, that was DW2, my lord, about DW2, there was no mention in WS. That's the same point.
that is one part. But the second part is that DW2 also does not mention about the brother.
My lord. No, my lord. DW2
page 61.
mentioned about brother, about,
Page 61,
my lord.
come to page 61, about 6-7 lines from below. Also, DW2 did not mention Muhammad Haider as his brother, but the proceedings said otherwise. This is the finding.
DW stated that the proceedings is elder sister. My lord, I am in the
No, at page 61,
61.
about 7-8 lines from below. Also DW2. Because you see, first part is about his sister Rukia.
My lord.
It says that the proceeding did not mention about Rukia as a sister. Then also DW2 did not mention Muhammad Haider as his brother, but the proceedings
My
said
lord,
otherwise.
My lord, the one brother is not mentioned by the DW2.
Yes.
My lord, the evidence is available before your lordship, and those brothers are available in the voter list, my lord.
No, that may be
Whether
available.
for such missing only one part, my lord, can be, my lord, entire evidence may go, my lord.
You see, it can be a tutored witness. We don't know.
My lord. My lord, my lord,
You have seen the movie Mr. Natwarlal. There is a very famous evidence disclosed by the hero of that movie. You've seen that, no?
my
It's a
lord,
wonderful movie.
I enjoyed the music, the songs of the cinema, but
No.
son, the cinema I
lawyer-
have not seen, my lord.
For a lawyer, that is a must. This one, and then the other is my cousin Vinny.
Suddenly, the siblings also he stated that brothers in the Mujibur and Haidar, my lord, these two brothers were voter in 1997 along with father, my lord. This type of minor inconsistency shall not be, my lord, as a ground to disbelieve the prime evidence, my lord. There may be, my lord, this has been held, my lord, in the this honorable court judgment, my lord, in Haidar Ali case. And relying upon the judgment of the my lord, Siraj Haq case. The minor inconsistency.
You're giving protection to the petitioner. Let us examine this. Names of the Learned Council are there in order dated 8/4/24, same names. 8/4/24, same party's name. But so, next paragraph, pursuant to order dated 8/4/2024, the records from the Learned Foreigners Tribunal is received. Stop. or the same requires further examination. Accordingly, issue notice returnable in 4 weeks. Was requisite.
Total list has
You have given extra copies?
my lord, given me, huh?
Given. Extra copies are given?
My lord, my lord, we have earlier given my lord.
Okay. The learned counsel for the petitioner has submitted that extra copies of the writ petition have been served on the learned counsel appearing for the respondents. Next para. In the meantime, the petitioner, namely Anwara Khatun, is directed to appear before the Superintendent of Police within bracket border,
No comment.
Nagaon. The below rupees 5,000 with those conditions, default condition, as well as the default condition. Next list after 4 weeks.
Deeply obliged.
Item 20 for motion.
May I please your lordship, it's a 39/2024 order. For linkage, I have next of kin certificate and Gaon Buya certificate. Gaon Buya came and deposed, and next of kin
Which
certificate
page is
is
the opinion?
at page 35. It's 2 month old opinion. 39/20.
And which are the main documents you're relying on?
And next of kin certificate for linkage, your lordship, page 129.
He came and deposed.
The officer, yes, your lordship. That's DW6. And Gaon Buya also came and deposed.
Okay. Okay. Right. Mr. A.K. Agarwal, and the counsel for the petitioner. Also had Government of India,
DJ Das.
DJ Das. CC appearing for respondent number 1, Mr. J. Sharma, G. Sharma, standing also for the FT matters representing respondent number 2, 4, and 6. 2, 4, 6, and 7. And Mr. H. Puli on behalf of Mr. A. Abhi, standing also for respondent number 3. And Mr. P. Sharma, an additional senior government advocate appearing for respondent number 5. Opinion is at page 35. Opinion dated 39/2024, passed by so and so and so and so. The reference police IMDD case number so and so. Notice extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police border, Borpeta, within 10 days and take bail 5,000. Those conditions and default condition. This after 4 weeks on receipt of records of the tribunal.
Much of it.
Twenty-one for motion.
I exhibited, my lord, 1966 voter list, my lord, as exhibit 1, my lord. Land document, revenue paying receipt, my lord, page number 19, exhibit 4, my lord. This is the document of 1954, my lord. My father's name is there, my lord. Page number 19, page 20 is the vernacular, my lord. It was issued on 27/6/1954. This was exhibited, my lord. And Gavura was, my lord. Written statement, my lord, page number 35, my lord, onwards. my lord. Gavura was also examined, my lord. Who issued the certificate exhibit, page number 33, my lord. My lord, the page 52, my lord. Page number 61. My lord, page number 61, third paragraph, the version of witness, my lord, is the name of the Gavura, my lord. This is the cause of disbelief, my lord. 61, third paragraph, the version of the witness, Somiruddin, the Gavura, cannot be accepted. My lord, the that is not reflected in the judgment also, my lord. My lord, I could not obtain the copies of the DWs, my lord. Petitioner herself was examined as DW1. My lord, the certificate is at page number 33, my lord. Father's name is there. Page 34 is the vernacular. This is exhibit 19, my lord.
Time and again, we are telling you, unless your state government activates the machinery to educate this, not educate is the wrong word, to refresh their skills in the tribunal, it lead you to nowhere. Entire exercise would be a futile exercise. I'll give you one example why we are abruptly coming to that issue that we should give protection. Come to page 61. Third paragraph, last 3 lines. Moreover, he did not produce the counter folio of the certificate because the tribunal and that he did forward a copy of the said certificate to circle officer, which was made mandatory by order dated 3/8/2019 by the circle officer. Correct?
Not so.
Remember the date, 3/8/19.
Yes.
Come to the certificate at page 34. The certificate is of 2017. How can that 2019 circular be applied in 2017 certificate and disbelieved?
Lordship.
So if you don't point out these things,
Okay.
Mr. A.L.E. Learned Counsel for the petitioner. Mr. D.J. Das, Candidate CGC, appearing for respondent number 1. Mr. G. Sharma, Candidate Standing Counsel for the FT matters, representing respondent number 2, 4, and 6. And Mr. H. Kuli, Ms. S.T.
N. Bedi
N. Bedi, I'm sorry.
on the keyboard.
I'm growing old. I won't remember names so easily. Always remind me. Bedi, Leonard, Ms. N. Bedi, Leonard Counsel, appearing on behalf of Ms. P. Barwa, Standing Counsel for respondent number 3. And Mr. P. Sharma, Leonard Additional Senior Government Advocate, appearing for respondent number 5. Yes. Page page 52, opinion dated P1 2023, passed by so and so in so and so, arising out of FTV so and so, SP inquiry so and so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. So notice extra copies in 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police, border, Dorong, Mongoloi, within 10 days. Take bail, default clause, list after 4 weeks and receipt of tribunal records.
Obligers.
Item 1 for admission.
Mr. Mazumdar, you are sitting as the Additional Advocate General. You are sitting as Additional Advocate General. Which is your matter? This
This is the matter. This is a habeas corpus matter. We have against the preventive detention under the PIT NDPS.
PIT and DPS, yes.
So your lordship will kindly first take up my writ application. I'll take your lordship straight away to the order of detention. I'll first go through the facts of the case. I'll state the grounds and come to the judgments. The order of detention, your lordship find at page 18.
The order is of 22nd May 2024. Page 18.
18.
1.
Yes.
I'll just read this order, Your Lordship, because this is the, we are challenging this. Whereas the police report and connected records, why I'm just reading it because there are stand I'm taking from this also. Whereas a police report and connected records have been laid before the undersigned by the Deputy Inspector General of Police, STF, Assam, Guwahati so and so, dated so and so, letter number so and so, Inspector General of Police, STF so and so, so and so. Whereas it has been proposed to detain so and so, so and so, so and so, Assam with a view to preventing him from engaging in illegal and harmful activities or illicit business of narcotic drugs from the repeated violation of the provisions under the NDPS Act 1985. Whereas on the perusal of the police report and the connected records, it appears that the said accused has persistently involved himself with the crime of illegal business of narcotic drugs since many years and was arrested in the following cases. There are 3 cases, Your Lordship. These 3 cases. Whereas it also appears from the police report that during investigation, the seized particulars suspected to be heroin in respect of the aforementioned cases were sent to FSL for examination, and FSL report indicated positive test for heroin. Whereas as intimated by Director General of Police, STF Assam, White so and so, that the accused so and so has been found to be a repeat offender under various sections of NDPS Act, and his detention under PIT NDPS is imperative to keep him out of business of illicit trafficking in narcotic drugs and psychotropic substances and break the network of drug supply in the district of Kamrup, so and so. Whereas I so and so, to the government of Assam, Home and Political Department and Detaining Authority under PITS on perusal of the police records and recommendation of the Deputy Inspector General, so and so, has been acting in a manner prejudicial to the provisions under NDPS by continuously indulging in illicit trade in narcotic drugs, even after his arrest several times, and therefore in exercise of the powers conferred under so and so, do hereby issue this order directing the above accused person so and so be detained under the PIT NDPS until further orders. This is the initial order. Here, Your Lordship, the first line we stated police report and connected records. So that part I'll come to later. Now, Your Lordship will kindly take up the page 21. This is the grounds of the detention. Here they have specified what are the grounds of detention, and just I'll read the few grounds like that. I'll not read the whole one. It's a long part. I'll just read the part where they have specified where on what ground they have detained. Page 21. So I'll read paragraph 3. It appears from the record that on so and so at about so and so information was received regarding transport of illegal drugs by an associate. The police team so and so had carried out a search operation to detect and intercept the vehicles by you and your associate to transport the banned contraband. During the interception by police at Sonapur Toll Plaza, your associate, Your Lordship, this is not the petitioner, petitioner's husband, was apprehended along with his Honda car and huge quantity of heroin drugs weighing so and so. However, you managed to escape from the spot on your Hyundai Creta car bearing registration number so and so. Later on, during your period of absconding in connection with so and so case, you were apprehended and arrested on so and so by North Guwahati Police Station for committing similar offences under the NDPS Act. This refers to North Guwahati PS case number so and so. Thereafter, you were arrested on so and so in connection with so and so. During investigation, you and Mofizul Haq were arrested, and after proper interrogation, it was found that you and Mofizul were involved in peddling of drugs all of the places in Guwahati city and the areas in Kamrup. This refers to PS case number so and so under section NDPS search. During the course of investigation, sufficient evidences against you and your accomplice were found, and on compilation should have been of investigation, charge sheet was submitted against you and your accomplice in STF PS case number so and so. Here, Your Lordship will see they have within bracket they have given provided the copies, the photocopy of FIR, GD extract, seizure memo, FSL report, counterfoil of CS are annexed here with and marked as annexure so and so. So these were provided, Your Lordship. Now in the second case, there are 3 cases, Your Lordship. The second case, I'm not reading everything. The second case also, your lordship, this is a Gitarnagar PS case. Here in this case, the bail has been granted to the petition. Just I'm making a mention, though they did not say here that he has been granted bail, but in this case, the bail was granted. Now, your lordship will see the next, here also, your lordship, they have marked the FIR and other copies have been given to me. Then the third case, your lordship, will be at page number 23, serial number 5. Here, your lordship, this is not Guwahati, PS case number so and so, so and so, so and so. Here in these other two cases, bail have not been granted. In one case, bail have been granted, and these are the FIR, GD, and Caesar memo, etc., has been provided to the petitioner, your lordship. And now, your lordship will kindly take up page 24, para 6. I am reading this because certain, your lordship, points I will raise my grounds on these. So I have just pointed out only on these. From the above, 3 number of cases in police station so and so, Gitarnagar, North Guwahati, and STPS, it is seen that you have been involved in the crime of illegal trafficking of drugs since long in Guwahati city and Kamrup district. You are engaged in illicit trade, drugs trade, thereby turning a large number of youth into addicts, harming not only the health and future of the youth, but also deprive the nation from quality human resources, which will have detrimental effect on the society at large, besides encouraging such addicts into other criminal activities. Further, it is observed that you are found to be habitual offender of such illegal drug trafficking in violations of the provisions of NDPS Act. In spite of your arrest in different cases, you neither mended your ways nor shown any remorse for your criminal acts, and you continue to get engaged in criminal activity to help with your accomplices. At present, you are in judicial remand, and is likely that you may be released soon. Though you are in judicial custody in connection of so and so, your probable release on bail will be seriously detrimental to large number of people. Your release may again lead to restart of illegal drug peddling under trade in the district of Kamrup. Here, I have just pointed this part, why I have been, I am in judicial remand. They say I am in judicial remand and that I may be released soon. And the second part, your probable release on bail will seriously detriment the large number of people. These 2 lines will have the implications I'll bring in later. So after this, your lordship, they have given me in the next page, representations could have been.
Post lunch. Mr. Sharma,
7 months.
it will not be possible to attend. The program I will not be able to attend. That's right. I just saw my itinerary, not possible.
Sunday.
There are
Wait, please. I was referring to page 24.
24.
Yes. Here your lordship will see at the last paragraph that however, inform that you have the right to make a representation and you may submit your representation against the order of detention through the concerned jail authority if you so desire. So there were your lordship authorities were number 1 was the principal secretary, state government of Assam. Then there is the detaining authority. Then number 3 is the advisory board. And number 4 is the deputy secretary, PIT NDPS division, Ministry of Finance. So there are 4 authorities. And in fact, on the next page, the petitioner's wife, who is the the petitioner, who is the wife of the detainee, filed the application, representation to the principal secretary with your lordship, the copy to the advisory board as well as the deputy secretary. Page 26 is the representation, and page 31, the copies were given to the advisory board and the deputy secretary, Ministry of Finance. So in the mostly 3 authorities this has been given because 1 and 2 authorities the same. So it has been given. Here, your lordship, it has specifically stated that out of the 3 cases, your lordship, in one of the case, the petitioner has been granted the bail, which has not been stated in the grounds, your lordship. That bail order, your lordship will find at page 35. I'm not reading the order, I'm just pointing out the date of the order. Page 35 is the order, that is 7/8/2021. So the order was passed much before the bail order was passed, much before the order of detention was issued. But in the grounds of detention, it has not been reflected. It is said that you are in judicial custody, you may be granted bail, or this has been stated. So this was not taken off. And so at one point here, I just want to point out that they have just maintained that I am in custody, and this bail was somehow not reflected in the order. Now, your lordship, my learned friend have already filed their affidavit, your lordship. Affidavit in opposition they have filed, and they have in fact in the affidavit in opposition annexed most of the documents that I have already annexed. Along with, your lordship, there are the page 52, annexure A, is the letter to the advisory board's letter. So the matter was referred to the advisory board, and the advisory board has given the order has been passed by the advisory board. That no, they have given the many dates are there. So the main order was passed on page 59. Page 59.
Mr. Say that they have confirmed the order.
Yeah, they have in this at page 63, the opinion is that the order was approved by the authorities. So the next page is the order passed by the government of Assam. Considering my representation and on the basis of the order passed by the advisory board, the order has been passed whereby my application was rejected and the order of detention was approved. The rest, the annexures that I have already annexed in the writ petition. So I'll not go into that. Now, your lordship, the points that I raise for challenging the detention order is that number one is the ground of delay. First ground is the ground of delay. Now, there is a ground of delay for considering my representation by the state government as well as by the central. I'll come to that, your lordship, point wise. Now, your lordship knows that my representation was filed on 35/2024. 35/2024. And the order of the state government was passed on 3/8/2024, about 2.5 months from the date of the representation. And here, your lordship, I like
Where is that order?
that order, your lordship will find at page 64. Page 64. Their affidavit. They have annexed, peruse and examine the representation dated 35/2024, and they have stated, and in fact, they have quoted the provision from the advisory board, and then ultimately they have rejected this, and this was done on 3/8/2024. So that is the number one, your lordship. There is a delay of about 2.5 months, which has not been, nowhere they have stated why they have taken so much time in considering my application, representation. That was the first point. Second point, your lordship, which is more important, the representation made to the central government, they have not yet considered till date. So that is about more than, it will be about, your lordship, 35, about 6 months. More than 6 months. That representation till date has not been considered. No order has been passed till today by the central government. So there is a delay of about 6 months by the central government, and about 2.5 months by the state government without specifically stating why there is a delay of 12 months. This is number one. Now, my second point is with regard to while considering my the detention order, providing me the opportunity to represent, I am supposed to be given the dossier or the documents on which they have relied while passing the detention. Now that's why at the very beginning I showed your lordship, they have given me about a few documents like the FIR, the FSL report, etc., etc. But now, your lordship, what has happened in all these cases, all the three cases? The one case, there is a status is like already 4 or 5 witnesses have already taken place, and in one case, no witnesses have been examined. But in all these cases, nothing was recovered from me directly except the case where I have got bail. There 8 grams of heroin was recovered from me, which was less than the commercial quantity, so bail was granted in that. Apart from that case, the other 2 cases, your lordship, nothing was recovered from me, and I was arrested on the basis of the statement of the co-accused. These statements, nothing has been provided to me. This is so. Why I am trying to point out, because the whole case was built upon the statements of the co-accused, and I was arrested on that ground. And these documents were not provided. They have provided the FIR. I'm not denying that. FIR, the FSL report, etc. But even the police report they have provided. But they have not given these copies, which are very essential. This is the second point.
Can you tell us the date? Your representation is on 38, 2024.
35. Oh, sorry, it was
35.
2020.
Yes, is your representation.
Yes, and there
this charge sheet was submitted when?
In all these cases?
No, in the one which where the copies were not given to you, that statement of the accused,
that
co-accused.
I'll just, it is already there, I think, in the affidavit. Just a moment.
Prior or post 35, 2024.
Because in one case, the STF case, already the matter is on evidence stage. So obviously there should be charge sheet as well as the witnesses. 4 or 5 witnesses have taken place till that point of time.
Because there are pronouncements which says that, if I recollect it correctly, that premature disclosure of the case materials may not be given.
No, that is when, your lordship, this in the inquiry stage, obviously. After that, obviously, it has become, because we can always go for
that you get copies.
because these matters have already went to the court. One is in the evidence stage, one is two of them in the evidence stage. All the 3, but in one of the cases, no witnesses have yet been examined. In the other 2 cases, it is.
That's why I was requiring that date.
I'll just try to find out.
It's okay. You take your time.
I'll try.
You take your time.
It is there, but somehow
It's okay.
Yes. In the first case, I'll just point out in fact, in the letter, the representation itself, it has been stated in the STP case 6 of 2023, your lordship, 14 prosecution out of 14 prosecution witnesses, 4 witnesses have already been examined by the court. 3 independent witnesses, Caesar witnesses failed to prove the case of the prosecution. This has been on the merit. I'll not go on the merit, but this is the stage. Then in the Gitanagar PS case, page 27, I am reading here. In the Gitanagar case, your lordship, the bail was granted. That has been stated. Then in the charge sheet has been laid down on, in that case, 16/8/2021, long back. And no prosecution witness has turned up till date.
Please give the case number.
Lordship will kindly take up page 26.
No, I go by your word. Just give me the date of the, in the case number.
Case number STF PS case number 6/23. The first case. STP PS case. STP PS case number.
Special Task Force.
Yes. Special Task PS case number 06/2023. In this case, your lordship, the status as of that day, your lordship, it was 14 out of 14 prosecution witnesses, 4 witnesses have been examined by the court.
As on 30,
Obviously, on that
35.
at that day, it may be 1 or 2 more by now.
No, it's okay.
And then the next case, that is, your lordship, Gitanagar PS case number 219/2021, page 27. 219/2021. This is Gitanagar PS case. In this case, charge sheet has been filed on 16/8/2021. Here, a contraband of about 8.65 grams. have been-
8.65 grams.
Yes, recovered from the petitioner, which is less than the commercial quantity. So bail was granted to the petitioner on 17/8/2021. So this is the second one. Third case is, your lordship, page 28, North Guwahati PS case number 111/2023. Here, your lordship, charge sheet was filed on 28/12/2023. There are 9 prosecution witnesses.
Please give the date again.
The charge sheet date is
Yes,
28/12/2023.
yes.
And here, your lordship, there are 9 prosecution witnesses. At that point of time, no prosecution witnesses have turned up for evidence. So these are the 3 cases on which the detention order was passed. Now, your lordship, in that detention order, which, your lordship, I have read, they have given me the FIR, they have given me the DD extract, Caesar memo, FSL report, and counterfoil of the CS. Other than that, they have not given anything else. So basically, the statements and the evidences were not provided to me. So that is one point. Then, your lordship, second point that I raise at this stage. So that means the whole dossier which has to be provided to the detainee has not been provided. So this is my second ground on which I challenge. Now, third ground, your lordship, that I take is, since the accused is already in custody in 2 of the cases, so he is already in custody, your lordship. So what is the necessity of putting him under preventive detention? So at least in 2 cases, bail have not been granted. So he is already in custody, and custody for a long period of time. Bail have not yet been granted. Therefore, is it necessary for them to put him under preventive detention? This is the third point that I raise. Now, the ground that they cited for the preventive detention was that I have read on the last, read out to your lordship, was that he may be, they have presumed that he may be granted bail, and if he is granted bail, then he will be doing the illegal activities again. So this is a presumption, number 1. And in fact, your lordship, if they presume that I am entitled to, or I will be granted bail by the court, then there has to be, it cannot be a vague ground. They have to say, these are the reasons the petitioner may be granted bail by the court. Therefore, there is nothing, not a single whisper. They are saying that these are the ground why bail will be granted. Just making a vague statement that he may be granted bail, and therefore they want to put me under preventive detention. So that is where my third challenge lies here, which they cannot do. It cannot be a vague statement. There has to be some grounds, specific grounds, where the authorities find that, yes, these is the necessity he has to put, he can be detained on the, and the court may give bail because of what ground?
I'll just share a data.
Yes.
In the last vacations, there were 3 vacation benches. In respect of 2 honorable benches, the matters listed were more than 150. There was a third bench
Mhm.
where the matter listed was not even 60. This will give you an idea why there can be a presumption that bail may be granted. And where there would be a presumption that bail may not be
May-
granted.
Anyway, it happens, have to happen, Your Lordship. These are a part of advocacy, Your Lord. And also this depends
I'm
on.
not blaming you. You
No.
posed, I thought you posed a question to the bench and therefore the bench is answering.
No, I'm not posing anything to Your Lordship. All my questions are directed to my learned senior friend. It's just that I'm putting it before Your Lordship. Never. How can I pose, Your Lordship? It's not an order from Your Lordship. If it is a matter of writ appeal, then I could have posed the question, Your Lordship. I was a single judge. But as of now, it's directly to my learned senior. Anyway, Your Lordship. Now,
And he's
The-
questioning the authority through me.
obviously, obviously, Your Lordship will also question me to the client through me. Obviously. And then, Your Lordship, this part where again I am saying the whole basis is on an apprehension with a vague fact and apprehension.
Today, the culture of this came from a place where there is no government today. Lordship must have heard the news this morning. There was a no confidence motion. I think motion was passed. Macron probably is not there. Possibly. I've heard. I have not seen the news, but I have heard it.
So this,
Ah.
Oh.
I'm only there. Alone, mother.
not alone, Your Lordship, with a barrage of lawyers. Any
Context.
context? Here, Your Lordship, why I'm trying to point out that this matter was based on the apprehension that he will be released on. I'll come to some judgments on that. So I'm just giving my grounds one by another. Then straight away I'll go to the judgment. When my learned senior friend asked me how long you will take, I say I will not take much time. So I'm straight away taking Your Lordship to the grounds which I am relying. And then, Your Lordship, the most important ground, that is violation of Article 21. Here, Your Lordship, very specifically, I am pointing out that there has to be some compelling reasons for a detention of a person affecting Article 21 of the Constitution. And the Honorable Supreme Court has laid down various guidelines in that. I'll come to those. So that is the moot question whether the detention order violates Article 21 of the Constitution of India on the ground that there is no compelling reasons, or rather they have not even given any compelling reasons why he should be detained, on the ground that he's already in custody. And then what is the necessity for a detention order? So these are the grounds on which I rely. Now, Your Lordship, I'll give some judgments to Your Lordships so that each of this point I will put a judgment or get the copy. দুটা কপি সবৰে দুটা কপি আছে। So Lordship, first Lordship will take up the division bench judgment of this honorable court in the case of WP criminal 20 of 2022, Alia Begum. I have given 2 copies each of all the judgments, Your Lordship. First judgment that I'll refer, Your Lordship, kindly take up WP criminal 20 of 2022, Alia Begum versus State of Assam. This is by coordinate division bench of the honorable court, Your Lordship. Both the counsels are same, Your Lordship, in this case. Both sides. Lordship has got the judgment. কোনটো? WP 24 এটা আছে। প্লিজ মই এটা দি আছো। এটা বৰ্তমান এখন হাতত নাই। বৰ্তমান নাই। পিছত মোৰ পৰা দিব। So first matter you will also will take up Alia Begum. Counsels of both sides are same in that case. Here, Your Lordship, I'll take Your Lordship para 13, 1-3. We are on the same sides, Your Lordship, at that time. That is, this decision was, judgment was of 5/9/2022. This is a division bench of this honorable court. Here, Your Lordship will kindly take up para 13, 1-3. Before that, I'll just read para 7. So the 7 was answered later on. So I'll just read from para 7, just a few lines. From para 7, I'll start para 7. Learned counsel for the petitioner has taken us through the factual matrix arising in this case and has contended that in all the 3 cases which are mentioned in the impugned order of detention, the petitioner has been granted bail much earlier. It was contended by so-and-so that even though before passing of the impugned order of detention, the detainee has been enlarged on bail. Still, however, it is mentioned in the detention order that he is lodged in jail and is likely to be released on bail. It is thus contended that the order of detention is a result of total non-application of mind on the part of the detaining authority. It was contended by so-and-so that the detainee has filed a representation dated 2/5/2022, whereas the petitioner filed the representation on 7/5/2022 before the detaining authority. However, the representations were considered and rejected by the respondent number 1 on 26/2022 and central government on 19/7/2022, which was served upon the petitioner on 28/7/2022. Thus, it is clear that representation was considered by the respondent authorities after almost 3 months. Learned counsel for petitioner so-and-so has contended that the relevant documents are not provided to the detainee, which has prejudiced the rights of the petitioner. The same is violative of so-and-so. Basically, on the same contentions are there in this case also. Now, Your Lordship will straight away go to the para 13. Sorry. para 10, para 10. Para 10, the other point was also taken care. Para 10. Upon considering the submissions made by the learned counsels for the parties, and on a bare reading of the impugned order dated so and so, it clearly transpires that the order of detention is based on 3 cases enumerated herein above. Para so and so of the impugned order are based upon involvement of the detainee in the criminal cases registered under the provisions of the NDPS Act, read with the provisions of the IPC. It is also evident from the impugned order that the detaining authority has an apprehension that the detainee who is lodged in Central Jail Guwahati is likely to be released very soon. It is also mentioned in the order that such release of the detainee appears to be seriously detrimental to a large number of people, mostly young generation of the society. It is further averred that after such release, the detainee will resurge in illegal trafficking of drugs, and specifically averred that once the detainee is released on bail, he will again continue the criminal activity. So basically, your lordship, similar along with this matter. Now, your lordship will take, I'll take your lordship to the order, para 13, 1-3. Secondly, it is also noticed that the detainee filed a representation on 2/5/2022. Oh, no, sorry. Para 12, para 12. Para 12, the decision has been taken by the court. At this juncture, para 12, at this juncture, it would be appropriate to refer to the order dated so and so passed by the Commissioner Secretary Government of Assam Home Department, wherein a reference is made to the communication dated so and so addressed to the superintendent to detaining authority in relation to the representation dated so and so filed by the detainee and the representation dated so and so filed by the petitioner, informing the detaining authority that the detainee is in jail in connection with so and so case. It is a matter of record that when bail was granted to the detainee by the competent court, the state was being represented by the public prosecutor, and therefore on the date on which the detention order was passed, that is on so and so, the detaining authority has constructive knowledge of the fact that in all the 3 cases which have been made the basis of detention order, the detainee is already enrolled in bail, and therefore the very mention in para 9 that he is in jail in connection with those 3 cases exhibits total non-application of mind on the part of the detaining authority, which renders the impugned detention order vulnerable and likely to be struck down. As the impugned detention order is passed much after the detainee was enlarged on bail in all the 3 cases, the same lacks application of mind. On the grounds mentioned herein above, the impugned order of detention dated so and so smacks of total non-application of mind, and the same is violative of Article 21 and 22 of the Constitution of India. Here, your lordship, in all the 3 cases, bail has not been granted, but in one case it has been granted, but they have not reflected that in their order. Now, your lordship, para 30. Secondly, it is also noticed that the detainee filed the representation on 2/5/2022 and the petitioner filed the representation on 7/5/2022, copies of which were sent to the concerned authorities, including the advisory board, whereas secondly, it is noticed that the detainee filed a representation on 2/5/22 and the petitioner filed representation on 7/5/22, copies of which were sent to the concerned authorities, including the advisory board, whereas the same were considered and rejected by an order dated 26/2022, passed by the Commissioner Secretary Government of Assam, Home and Political Department. The central government rejected the representation filed on 19/7/22, almost about 75 days. Thus, detaining authority as well as the central government authority has considered the representations filed by the detainee as well as petitioner as next friend of the detainee in a delayed manner, which has prejudiced the fundamental right of the detainee and thus violated Article 21 and 22 of the Constitution of India. So here, your lordship, in this case, in both the central government as well as the state government have considered and rejected it. The state government did it on 26/22, about 1.5 months, and the central government did it in after 75 days. And that was found to be very delayed manner, and therefore it violates 21. Here your lord say 2.5 months by the state government and not even considered by the central government till date 6 months. So much of delay. Now in para 14, I am reading this paragraph because this is a judgment of the apex court which is referred to. I have also, I think, given a copy of this judgment, but I'll read it from here, then it will save some time. The Honorable Apex Court in the case of Ummu Sabina has referred as under. I'll read this. This is important. Now the question is whether the aforesaid manner of consideration and rejection of representation by the central government is in accord with the principles laid down by the court in this aspect in several cases. It is clear in this case that the central government took about more than 2 months, that is whole of April and May, and ultimately rejected the representation only on 6/6 so and so, whereas representations were made on 3/33/2011. Reference in this connection may be made to the Constitution Bench decision of this court in the case of K.M. Abdullah Kuni versus Union of India. The unanimous Constitution Bench speaking through K. Jagannath say Justice so and so, noting the constitutional provisions under subclause 4 and 5 of Article 22, was pleased to hold that neither under the Constitution nor under the relevant statutory provisions has any time limit been fixed for consideration of representation made by the detainee. The time limit, according to the Constitution Bench, has been deliberately kept elastic, but the Constitution Bench lay emphasis on the expression as soon as may be in subclause 5 of Article 22 and held that said expression sufficiently makes clear the concern of the framers of the Constitution that the representation should be very expeditiously considered and disposed of with a sense of urgency and without any voidable delay. Considering the aforesaid provision, the Constitution Bench held that there should not be any supine indifference, slackness, or callous attitude in considering the representation. Any unexplained delay in the disposal of the representation would be a breach of the constitutional imperative, and it would render the continued detention impossible and illegal. In support of the said conclusion, the learned judges of the Constitution Bench relied on various other judgments mentioned in so and so. In a subsequent judgment of so and so, the 3-judge bench of this court, relying on the ratio of the Constitution Bench in so and so, reiterated the same principles from para so and so to so and so. So and so, everything has been given in your lordship. And then it has in another subsequent judgment of the court in so and so, this court, while reiterating the aforesaid principle, found that representation was received by the central government on so and so, and then comments were called for by the state government, and the same were received by the central government on so and so, and representation was rejected on so and so. This court held that para 22 of the judgment that the internal movement of the file thus took 4 days, and this court found that this inaction in taking up the representation for 6 days in unexplained, and the mere ground was that there were 40 or 50 representations pending for disposal, is not a valid ground, valid justification. This court found that such delay was the continued detention of the detainee, and the detention order was quashed. So it has to be as expeditiously as possible, not 2.5 months, 3 months, not even 6 months. The central government is still not considered. That is beyond anything else. Now, your lordship, para 16. This is another judgment. Here, another point has been taken care of. The Honorable Apex Court in the case of so and so, having carefully considered the submissions made on behalf of the respective parties, we are inclined to hold that extraordinary powers of detaining an individual in contravention of the provisions of Article 22(2) of the Constitution was not warranted in the instant case, where the grounds of detention do not disclose any material which was before the detaining authority, other than the fact that there was every likelihood of so and so being released on bail in connection with the cases in respect of which has been arrested to support the order of detention, which I am saying. Article 21 of the Constitution has been stated. I'll not read that, your lordship. Now, para 18. Here again in para 17, the judgment and other judgments have been referred by the court, which is not discussed. I am also not reading those. It is also evident from the affidavit in opposition that the detaining authority has clearly stated that the detainee has been charge sheeted in all papers could not be provided to him. In fact, however, remains that the detention order is based on the very 3 cases where the detainee has been charge sheeted and non-supply of the relevant materials would be violative of Article 21, 22 of the Constitution of India. And on that ground, the impune order of detention states vitiated. Now, the para 19, I am not reading, Your Lordship, because that presumption in this case I am not taking up. So this resultantly, it was a para 20, the writ petition was allowed and the impune order was quashed. So, Your Lordship, 2 specific points have been discussed by this honorable court in this case. First is delay, and the second is there is no specific ground on which they have stated bail will be granted. Then now comes the second case, Your Lordship. This is also from our court, a division bench in WP Criminal 25 of 2022. This is Babul Ahmed. This is a short judgment. I'll just not read all the paragraphs. This is also a coordinate bench judgment, Your Lordship. Para 4. Amongst other, in the writ petitioner, the petitioner states that the representation to the Commissioner Secretary Government of Assam Political Department, the records reveal that the said representation was received by the Commissioner in the Home Political Department on so and so, but disposal of the representation was made by the order dated so and so as per the order of the Commissioner and Secretary. Accordingly, the contention is raised that the delay in disposing the representation is beyond the permissible limit, and because of such delay, the detention is vitiated. The petitioner raises another contention that the petitioner detenue No, it was question. Lordship, I have not got the copy, I think. Yeah, there might have been misplaced. I'll give my copy if required. I'll just read it, Your Lordship. As of now, I'll read it. Oh, no, that may have been. Regina Begum copied it. I'm trying. Let me see if it is here. If it is possible, I read it here. Paragraph 4, Your Lordship. Amongst other, in the writ petition, the petitioner states that the representation to the Commissioner Secretary Government of Assam in the department was made on so and so. The records reveal that the said representation was received on so and so, but the disposal of the representation was made by the order dated so and so, as per the as per the order of the Commissioner and Secretary. According to the contention raised in that delay in disposing the representation is beyond the permissible limit, and because of such delay, the detention is vitiated. The petitioner raised another contention that the petitioner detainee was not informed that he has a legal right to make a representation to 4 of the authorities, namely the detaining authority, the state government, the advisory board, as well as the authorities under the central government. Here, Your Lordship, they have given all the 4 authorities they have mentioned, and we have given each and every authority representation was. Now, para 5. It is a settled proposition of law that in case of preventive detention, there is an inherent right, legal right bestowed on the detainee to be informed by the detaining authority. There is a legal right to make representation to all the aforesaid 4 authorities, which has been done, we have also done. But without going into the second contention raised, when we take note of the first contention, the relevant dates as indicated above to be that the representation was made on so and so to the Commissioner Secretary Government of Assam in the political, and the representation was received by the Commissioner Secretary on so and so, but the same disposed of by an order dated 27/2022. In other words, the disposal of the representation made on so and so was made after a period of 3 months. Here in this case, it's 3 months. So, Your Lordship, I'll not read the next paragraphs. I'll straight away go to para 9. The facts of that case is there, so I'm not reading it. Now, para 9, again, another law has been relied on from the Supreme Court has been relied by this honorable. The law in respect of this has been settled by the Honorable Supreme Court in its pronouncement of Rashid Kapadia versus Medha Gadgil and others reported in 2000 so and so. Here they have stated, it is well settled that the right of a person who is preventively detained to make a representation and have it considered by the authority concerned as expeditiously as possible is a constitutional right under Article 22(5). Any unreasonable and unexplained delay in considering the representation is held to be fatal to the continued detention of the detainee. The proposition is too well settled in a long line of decisions of this court. We do not think it necessary to examine the authorities on this aspect, except to take note of a couple of judgments where the principal has discussed in detail. They are so and so. I'm not reading those judgments. Now, para 10. In reading of the afore extracted provisions of the Honorable Supreme Court in so and so makes it discernible that when a detainee under preventive detention makes a representation, it has to be considered by the authority as expeditiously as possible, as it is a constitutional right under Article 22(5) of the Constitution, and any unreasonable and unacceptable delay in considering the representation would have to be held to be fatal to the continued detention of the detainee. In the matter that was before the Honorable Court, so and so, the authorities took about 1 month to dispose of the representation of the detainee concerned, and even the period of 1 month taken by the authority to dispose of the representation was viewed by the Honorable Supreme Court to be beyond the expeditious disposal as required in the case of preventive detention. So here 2.5 months. Then the court in the next paragraphs, after considering the decisions, have set aside the detention on the ground of delay. In that case also, it was a delay of 2.5 months. Para 13, it says 2.5 months. So it was. So these are the two judgments where delay has been specifically considered by the Honorable Division Bench of this Honorable Court and have granted quash the order of detention. Now, Your Lordship, the third case that I will rely is the case which has been referred to in all the subsequent decisions here. That is 2011 5 SCC 244. It is Rekha versus State of Tamil Nadu. This judgment has been referred in mostly all of the judgments that are there on preventive detention, because these are 3 judgments of the Honorable Supreme Court. 2011 5 SCC 244. And this is Rekha versus State of Tamil Nadu. Here I'll take Your Lordship to paragraph 11. First paragraph 11, Your Lordship. In our opinion, the detention order in question only contains ipse dixit regarding the alleged imminent possibility of the accused coming out on bail, and there was no reliable material to this effect. Hence, the detention order in question cannot be sustained. So here, only on that ground, basically the ground that there is an imminent possibility of the accused coming out on bail. So what they have stated, that he may be granted bail. It's a presumption that is specifically stated. Now I'll read paragraph 12. Moreover, even if a bail application of the petitioner relating to the same case was pending in a criminal case, the detention order can still be challenged on various grounds, that the act in question related to the law and order and not public order, that there was no relevant materials on which the detention order was passed, that there were malafides, that the order was not passed by a competent authority, that the condition precedent for exercise of the power did not exist, that the subjective satisfactions are irrational, and there was non-application of mind, that the grounds are vague, indefinite, irrelevant, extraneous, non-existent, or stale, that there was delay in passing the detention order, or delay in executing it, or delay in deciding the representations of the detainee, that the order was not approved by the government, that there was failure to refer to the case to the advisory board, and the reference was belated, etc. Next paragraph 13. In our opinion, Article 22(3) of the Constitution of India, which permits preventive detention, is only an exception to Article 21 of the Constitution. an exception is an exception and cannot ordinarily nullify the full force of the main rule, which is the right to liberty in Article 21 of the Constitution. Fundamental rights are meant for protecting the civil liberties of the people and not to put them in jail for a long period without recourse to lawyer and without a trial, as observed in so and so and so and so. So, the impression of what it is effect is substantial term of imprisonment by the exercise of executive discretion without trial lies uneasily an ordinary concept of the rule of law. Article 22 hence cannot be read in isolation, but must be read as an exception to Rule 20, Article 21. An exception can apply only in rare and exceptional cases, and it cannot override the main rule. Now, paragraph 14. Article 21 is the most important of the fundamental rights guaranteed by the Constitution of India. Liberty of a citizen is a most important right won by our forefathers after long historical order struggles. Our founding fathers realized its value because they have seen during the freedom struggle civil liberties of our countrymen being trampled upon by foreigners, and that is why they were determined that the right to individual liberty would be placed on the highest pedestal along with the right to life as the basis right of the people of India. I will not read the others. It is elaborating on Article 21. I'm not reading. I'll go to 17. Article 22(1) of the Constitution makes it a fundamental right of a person detained to consult and be defended by a lawyer of his choice. But Article 22(3) specially excludes the applicability of Clause 1 of Article 22 to cases of preventive detention. Therefore, we must confine the power of preventive detention to very narrow limits. Otherwise, the great right to liberty won by our founding fathers, who were also freedom fighters after long orders and historical struggles will become negated. Now, Your Lordship, I'll straight away take Your Lordship to paragraph 30. This is important. Whenever an order under preventive detention law is challenged, one of the questions the court must ask in deciding its legality is, was the ordinary law of the land sufficient to deal with the situation? If the answer is in the affirmative, the detention order will be illegal. In the present case, the charge against the detainee was selling expired drugs after changing their levels. Surely the relevant provisions of the penal code and drugs and cosmetic acts were sufficient to deal with the situation. Hence, in our opinion, for this reason also the detention order in question is illegal. Here, Your Lordship, I am entitled to be under trial under the NDPS Act. An NDPS Act can take care of my, Your Lordship, illegalities and legalities. Therefore, it need not require preventive detention to be brought to, Your Lordship, put me in custody, because NDPS Act itself is a very strict act, Your Lordship. Now, Your Lordship, I'll take Your Lordship to para 35. It must be remembered that in cases of preventive detention, no offense is proved, and the justification of such detention is suspicion or reasonable probability, and there is no conviction which can only be warranted by legal evidence. Preventive detention is often described as jurisdiction of suspicion. The detaining authority passes the order of detention on subjective satisfaction. Since Clause 3 of Article 22 specifically exclude the applicability of Clause 1 and 2, the detainee is not entitled to a lawyer or right to be produced before a magistrate within 24 hours of arrest. To prevent misuse of potential dangerous power of law of preventive detention has to be strictly construed, and meticulous compliance with the procedural safeguards, however technical, is, in our opinion, mandatory and vital. Para 36. It has been held that the history of liberty is the history of procedural safeguards. These procedural safeguards are required to be zealously watched and enforced by the court, and the rigor cannot be allowed to be diluted on the basis of the nature of alleged activities of the detainee. So it cannot be on the just on the activities. It has to be very specifically enforced, Your Lordship. As observed in Switch, I'm not reading each and everything, Your Lordship, it will take a long time. Various decisions have been referred to, and so I'm not reading all. Now, Your Lordship, para 39. Personal liberty protected under Article 21 is so sacrosanct that so high is the scale of constitutional values that it is the obligation of the detaining authority to show that the impugned detention meticulously accords with the procedure established by law. The stringency and concern of the judicial vigilance is needed was aptly described in the following words. Then comes the question upon the habeas corpus. It is a general rule which has always been acted upon by the courts of England that if any person procures the imprisonment of another, he must take care to do so by steps, all of which are entirely regular, and that if he fails to follow every step in the process with extreme regularity, the court will not allow the imprisonment to continue. For the reasons given above, the appeal is allowed, the impugned order is set aside, the detaining order is quashed. So basically here, Your Lordship, the two issues that I have taken, basically the issue of delay as well as the issue that there is nothing has been stated why he has to be that's because the ground that he will be released on bail. This cannot be a ground for detention. And thirdly, Your Lordship, the issue that was taken care of, it is violative of Article 21 of the Constitution of India. Then another judgment, Your Lordship, will find 2012 2 SCC 176 Human Ongbi Lemba Lima versus State of Manipur. Here, Your Lordship, I'll take to paragraph 23. Your Lordship. Having carefully considered the submissions made on behalf of the respective parties, we are inclined to hold that extraordinary powers of detaining an individual in contravention of the provisions of Article 22(2) of the Constitution was not warranted in the instant case, where the grounds of detention do not disclose any material which was before the detaining authority, other than the fact that there were every likelihood of so-and-so being released on bail in connection with the cases in respect of which has been arrested to support the order of detention. Next, para 25. When the courts thought it fit to release the appellant's husband on bail in connection with cases in respect of which he has been arrested, the mere apprehension that he is likely to be released on bail as a ground of his detention is not justified. Para 27. As has been observed in various cases of similar nature by this court, the personal liberty of an individual is the most precious and prized right guaranteed under the Constitution of Part 3 thereof. The state has been granted the power to curb such rights under criminal laws as also under the laws of preventive detention, which therefore are required to be exercised with due caution as well as upon a proper appreciation of the facts as to whether such acts are in any way prejudicial to the interest of the security of the state and its citizens, or to seek to disturb public order and order warranting the issuance of such an order. An individual incident of an offense under the penal code, however heinous, is insufficient to make a case for issuance of order of preventive detention. In our view, the detaining authority acted rather casually in the matter in issuing the detention order to the High Court, also appears to have missed the right to liberty as contained in Article 21 of the Constitution and Article 22 thereof, as well as the provisions of Section so-and-so of the Criminal Procedure Code. So here, Your Lordship, the point that it stated that basically that once the person may be granted bail, this was the ground on which he was kept in detention. In this case also, that was the ground on which he was kept in detention. Then Your Lordship will kindly go to next case, that is 2011 10 SCC 781. This case was actually referred to in our division bench judgment, which I have read. This is Ummu Sabina versus State of Kerala and others. Paragraph 6. Same. This is why I'm not reading. These are paragraph 6, 7, which has been quoted by the the Honorable Division Bench, 9, 10, 11, and 13, Your Lordship. The 13, there is one issue which was not there taken up in the earlier case. That is, there is an objection. That we find the taking up the second objection first, we find that the question of delay was so and so, so and so. But insofar as the question of technical plea, which has been raised by the Land Council on the question of prayer of habeas corpus petition is concerned, we are constrained to observe that in dealing with writ of habeas corpus, technical objections cannot be entertained by the court. So here, only one point I would like to point out, apart from which has already been stated, that is the technical points should not be taken into, objections cannot be taken up by this court here. If any technical points have been taken up by the other side. This
The
has,
lordships were referring to this court, means their court,
there, obviously there,
not of this court.
not of this court, because no, it says High Court. It's the paragraph 13, it says High Court. It says High Court. So High Court could not be, High
No,
Court
no. No, you see the language, that's why I have commented.
taking up the second objection first,
Hmm.
we find that the question of delay was asked before the High Court, as it appears from para so and so of the impugned judgment. But in so far as question of technical plea, which has been raised by the Learned Counsel on the question of prayer of habeas corpus petitions is concerned, that is obviously in the High Court. We are constrained to observe that in dealing with writs of habeas corpus, such technical objections cannot be entertained by the court. So when there is some technical objections, in the other case, actually there was a technical here that is not there, but anyway, I'm just pointing it out. That cannot be taken by the court. Then para 17, Your Lordship, following the aforesaid time-honored principle, we make it very clear that if we uphold such technical objections in the proceedings and send the matter back to the High Court for re-agitating of the questions, the same would deprive the detainees of their precious liberty, which we find has been invaded in view of the manner in which the representations were unduly kept pending. We therefore overrule the aforesaid technical objection and allow the second. So what they made in that was I remanded back before the High Court to
So
consider this part. So
that is
court
why-
says no.
Satisfy that word this refers to that court
That-
only.
Right, that exactly. Then Your Lordship, I will take up two judgments. Sorry, one more judgment. That is, a judgment is State of Manipur versus Buya Mayum Abdul Hanan. Para 20.
Which one? What is the name?
This is State of Manipur versus Buya Mayum Abdul Hanan.
No, I don't think.
From Diana.
No, I don't think.
Oh, I'll wait for, let us keep that for the moment, you know, so I'll go to other matters. Citation to that now. No, I can look at my copy at a query. It is night. Copy at a one idea. Belek kita dekhai lang.
No, just give it, we'll, just say the number, we'll find it out.
This
No,
is a
just tell
Supreme
us-
Court judgment, but somehow this is not.
No, just tell us the name.
In fact, in this, this is a State of Manipur and others versus Buya Mayum, B-U-Y-A.
Just a moment.
Yeah.
D for Delhi,
No, not D, B for Bangalore.
B, B,
B-U-Y-A.
Yes.
M-A-Y-U-M. M-A-Y-U-M.
there is separate words or different?
Same word, same.
Uh,
Buya
B-U-Y-A.
Mayum.
M,
Buya Mayum. Y-A-M. Y-U-M. M-A-Y-U-M. And then it is Abdul. A-B-D-U-L Abdul. Hanan. H-A-N-A-N.
it's reported.
Elias Anand. This
Yes.
actually, this is a printout copy from the, I think.
No,
not
this
the
is-
printout, no?
This is reported.
This is reported. This is reported, but here actually I got a printed copy from the net most probably. Or PDF copy December. Therefore, I couldn't make the citation here. Okay, এটা copy কৰি দিয়া আছে এইটো আছে নি এটা copy এটা নহব ঠিক আছে হ'ব No, I'll give a copy of this. Your
It's not required. We have it.
I'll just refer to the paragraphs and then I'll just point out.
That is only with regard to copies. This case is only with regard to copies that you should be.
Yes,
you
no,
should be
here
given
with
copies.
regard to that dossier which I said,
Huh.
that you have to give all the copies.
Only on that
basically,
point.
That is given.
Only that
That
point.
that
Huh.
other points I'm not relying in this. So that point is by this. Then your lordship will kindly take up the two judgments of our honorable court, though these are single bench judgment, but I'll just refer to them because they have referred to various. First is a case of
Yes,
diversity.
Just one. Make a note first. What is the paragraph in this Buma Mayung case? What is the paragraph?
This is a, actually I have.
Just give
downloaded,
paragraph.
I don't know whether it will be the same there,
Eh,
but
eh,
anyway,
Yes.
there are 20, 21 and 24. here. Sorry,
20
17.
20 is.
17, 17. I don't know whether it is same or not.
You're referring to 17.
17, it is well settled that right to me. I'll just hand over this here.
No, it's okay. It's well settled. Yes.
Yes, that
That
is
a right to make representation.
that paragraph, para 17. Then your lordship 20, 20. This is referred to another judgment there.
Learned Council also relied.
Yes, this
Ah.
one. And then your para 21 is a decision. It's a
That's the
legal position. Yes, these are.
Okay.
And then para 24. So last
24, in other words.
well, yes, these are the. Okay. Then I'll take your lordship to the judgment of this honorable court. The two judgments, though these are judgment of the honorable single bench, but it has quoted various judgment of our court as well as the honorable Supreme Court. First is Devarshi Kashyap versus Union of India. Huh? Suman.
Yes.
Here paragraph 11. Paragraph 11 has been stated as 11.1234 like that, where the court has specifically considered each and every point in a different perspective. This is a plea regarding non-application of mine, where I'll read your lordship the para 11.4. 11.4 is one of the points that I have taken. This is with regard to a particular case, 86 for SSC 416. Law is well settled that while issuing the order of detention, the detaining authority must record satisfaction as regard the likelihood of the detainee being released on bail. It has been held that the mere fact that a bail application submitted by the detainee was pending consideration before the court by itself would not be a ground to pass an order of detention. So here, just a bail application on the basis of which they said he may be granted bail would not be a ground. 11.5 years next. In Amritlal Swenso Supra, the Honorable Supreme Court, while laying emphasis on the law laid down in the case of Swenso, has further observed that there must be cogent materials before the officer passing the detention order that detainee is likely to be released on bail. The inference must be drawn from the materials on record and must not be ipse dixit of the officer passing the order of detention. So here, your lordship, nothing has been stated. Any cogent material has not been given. Why he'll be given bail? Then, your lordship, 11.7. In the case of Union of India versus so-and-so reported in so-and-so, the Honorable Supreme Court has held that when detention order is passed in respect of a person already in jail, the detaining authority should apply their mind and show their awareness in these regards in the ground of detention and the chance of release of such person on bail. The necessity of keeping such person in detention under the preventive detention law is clearly indicated. From a careful reading of impugned order of detention dated so-and-so and so-and-so,
But
it is
Mr. Manan, with all respect to the authorities cited, but you see, especially with regard to this Amrit Lal, reference to the judgment of Amrit Lal.
Amrit Lal, yes.
Yes.
This has been
This
referred.
is-
These are two judgments
No,
of the
it's
Supreme
okay,
Court.
but I'm just
not
trying to
taking-
analyze, I'm just trying to analyze this principle laid down. Now, how would that inference be drawn?
First, your lordship, the very moot question which your lordship will ask is that why will that person be granted bail? How the authorities know that he will be granted bail? This is the very moot question. Who will answer that?
That's
And
what
on
the
that
query is.
basis, you keep a person on detention. That cannot be. That is what it has been said in the
No,
next
but
case.
here
That
it
is.
says, here it says
Hmm.
that there must be cogent materials that he'll be released, likely to release. So
What
that
is the
cogent
cogent
material will never be there.
And that is what it states in the next judgment, that it has to be there in the order. That is why I'm reading the other paragraph. 11.7 and 11.8. So there has to be, because this 11.7 and 8 clarifies the earlier one. So that is it. Now, your lordship, 12 with regard to the unexplained delay in disposal of representation. So many judgments have been recorded. I will not read here. I've already read some of these judgments. I'll just give the paragraphs, your lordship. Paragraph 12.5, 12.6, 12.7, 12.8. These are all actually reference to the Honorable Supreme Court judgments. So all these judgments are not bringing and putting it through this order, your lordship, judgment of this Honorable Court. 12.5 to 12.8, your lordship. 12.5 to 6, 7, 8. I'll not read. Same thing has been given with regard to, there are cases where even in 11 days delay, the court has set aside. 17 days delay. These are the judgments where the delay of, in one case, 31 days delay. So that is basically on the ground of delay. So I'm not repeating it again. I'm just giving the judgments here. And then, your lordship, failure to furnish the police report and other documents to the detainee, that is 13. 13. Here, para 13. Here, para 13, your lordship, they have given me the police report. They have given the police report, but the other documents that I have already stated with regard to the witnesses, with regard to the statements, the co-accused statements, anything that has not been provided. So this has been taken note in the para 13. 13.2, this judgment of this division bench, and then para 13 itself. Then para 17, I will not make any submission because the case of Rekha versus State of Tamil Nadu has been, your lordship, recorded here. I have already read it. So this is the judgment where I have taken the grounds of these points. Then one more judgment, your lordship, Regina Begum. WP Criminal 15 of 2021. Here, I will just rely on just one point. Here, 9.6. 9.6. As indicated above, we have already found that the respondent number 1 has not responded to the representation of the petitioner even after 83 days on the
Just
date of
a
hearing
second,
and
paragraph?
communication rejected. 9.6. Here only I will rely on 2 paragraphs. 83 days, the communication rejecting the representation by the respondent was received by the petitioner, and as such, that is after 59 days of receipt of the representation by the respondent number 2, although the rejection order was passed, that is after 39 days. On the issue of delay in disposal of representation, this court would refer to the court and follow paragraphs from Devarsi Kashyap. So I will not read again. This is following Devarsi Kashyap. And then in paragraph 11, this is with regard to non-furnishing of the police report to the detainee. Here, I'll read it. Para 11.1. I have perused and considered the rival contention and also perused the detention order dated so and served upon the detainee on so and so. It is found from the contents of the detention order that the copies of the seizure list and the FIR of each of the 4 cases referred to in the detention order were served upon the detainee along with the police report. However, the entire dossier based on which the police report was prepared has not been furnished. The FIR and the seizure list are definitely not enough to prepare the police report, excluding the evidence collected against the detainee to form an opinion that preventing detention of the petitioner is necessary as an involvement of the detainee in the cases would be gathered only from the evidence collected in the investigation of those cases. That is what I'm trying to say here. In this case also, they have provided the FIR, the police report, as well as the FSL report, but they did not provide the statement of the accused on which basis the whole case was actually, the police report was made. Therefore, the court says that the dossier has not been given. Therefore, in this case, in the next paragraph, so the failure of the part of the detaining authority to furnish copy of the police documents to detainee, the learned counsel for the petitioner has referred to the detainee in Purna so and so and has submitted the detention order of the detainee has been vitiated due to non-furnishing of dossiers and the police report to the detainee. In the instant case as indicated above, copy of the police report and FIR and the seizure list were annexed with the detention order, but not the entire dossier, on the basis of which ground were found that the satisfaction was recorded for the detention of the detainee. Then I'll not read all. It is quoted the order of Purna Bora. Then in paragraph 11, Rekha, and therefore, in the last judgment, it does. It does. Affidavit to Gyan. Affidavit to Gyan. ইমান রিল্যাক্স হয়ে থাকিলে বেশ সেন্ট্রাল গভর্নমেন্টের মোক পাত্তাই নেই হ্যাঁ There is only one. I guess you can see already it was, or it will be. In both cases, I will be still in custody. When it will go, even if I win the operation success, patient died. The last judgment, your lordship, that is. Yes. Yes,
Right.
yes.
Now this, you are referring to this word dossier. I'm
Yes.
just trying to understand what that dossier could be.
Dossier means the whole case record, means police
No.
report as well as
No,
the other
that's the
cases.
difficulty. With all respect to whatever authorities you have cited, including the Supreme Court, you see, under the CRPC,
Mhm.
we have a specific provision where it is the requirement of law that only the papers on which the charge sheet is enclosed should be provided to the along with the charge sheet, and that is supplied to the accused persons. There is a corresponding entry in the Assam Police Manual. In Assam Police Manual also the same thing is provided, that the normally a case diary should not be provided to the court.
Hmm.
There is a reason for that. The reason is that in the case diary you will find various supervisory notes.
Exactly.
And therefore that apart from the IO, nobody else is entitled to.
Yes.
So therefore, a case diary cannot be provided. So therefore, this from this page 18 and 19, we see here,
Case diary has not been provided. It is
No,
the
it's
police
okay.
report.
but here you see, he is a repeated offender.
Mhm.
That is the consideration.
Yes.
And that there is a statement of the co-accused.
Hmm.
It's not even a consideration by the in the detaining order.
No, that we do not know because it has stated that police report. And what I am trying to show in the last judgment, Regina Begum, it says that the police report, on what basis it has been prepared.
But that
If
can't
it
be
is
provided.
prepared on the basis of the facts and circumstances on which I am otherwise
No,
detained,
that is
so
that
that
is the
facts and
investigation.
circumstances should be brought to my knowledge.
That is the investigation. How can that be?
No, that
produced?
CD is not required. For example, the statement of the accused, a co-accused, that can be provided because that has a, because on the basis of that in these cases, in all these cases, your lordship, detained.
That police report has
Witnesses,
been provided to
witnesses
you.
are, that is
See, the
before
police
us.
report has been provided to you.
Which one?
This police report.
Police report has been provided,
Huh.
but the grounds on which the report has been based has not been provided. That is what the Regina Begum and as well as Purna Bora and the division bench of this honorable court in 86 says that it has to be provided. That is what I am trying to point out. And the last one, your lordship, judgment that I am trying to point out, I am just ending it. Then if there is any other clarification, the judgment that is Banka Sneha Silla versus State of Telangana. There is this judgment, your lordship, I have given a copy, which is I think downloaded online, but this is reported in 2021, 9 SCC 415.
2021.
9 SCC 415. I can hand over this
Oh,
copy.
it's okay.
I can hand over this.
You have this.
Yeah, that is actually downloaded from the net. This copy, your last paragraph. Well, last paragraph. It has also considered all these cases which I have already discussed, so I'm not taking your lordship back to those cases, including Rekha versus State of Telangana. So your lordship will kindly take the last page, last paragraph. On the facts of this case, as has been pointed out by us, it is clear that at the highest, a possible apprehension of breach of law and order can be said to be made out if it is apprehended that the detainee, if set free, will continue to cheat gullible persons. This may be a good ground of appeal against the bail orders granted or to cancel bail but certainly cannot provide a springboard to move under preventive detention statute. We therefore quash the detention order on this ground. Consequently, it is unnecessary to go into any of the other grounds argued by the learned counsel, the petitioner, and accordingly, so and so, so and so, so and so. Here, your lordship, if on the basis that a person will be granted bail, they can very well argue in the authorities before the judge for bail that why it should not be given. In this case, under NDPS, section 37 is very well there. If that is satisfied, obviously bail can be granted. And then in that case, preventive detention will not be applicable. And then what happens, your lordship? If that is the only springboard that he may be granted bail, then that cannot be a ground. They can even go for cancellation of bail, but that cannot be a ground for preventive detention. Here, your lordship, specific ground was given that I may be granted bail, therefore I want to be kept in preventive detention. No doubt, in one case I was granted bail where it is not a commercial quantity. Rest of the cases, I'm not even granted bail till today. So I am already in custody. Even if, your lordship, this preventive detention goes, I'm still in custody until and unless there is a bail given to me. So that is my humble submission.
Let me give my reply tomorrow.
Not tomorrow. Tomorrow we have a lot of matters coming up.
Would be like money.
Half an hour to 45 minutes time will be seen.
You can just make your formal submissions, so only the legal submission will remain, so that we can go ahead, because the more we are nearing the vacation,
Completion.
no, vacation,
Yes.
more the
My lord, on,
pressure is building up.
my lord,
Once in the last week, your lordship, hardly anything will happen before the vacations.
So that's why,
yes,
if some part can be advanced, so that
Yes.
we have.
yes. my lord.
Ah.
My lord, difficulty is the law of this prevention of illicit traffic in NDPS is very stringent. But because of Article 22, the procedural safeguards, in the name of procedural safeguards, my lord, so many technicalities have come that here and there, if there is one aberration, then preventive detention order goes. My lord, so far as my learned friend is, my lord,
Someone in the government
my lord,
will have to engage a very good law assistant and have all the cases compiled,
my lord. At times, my lord,
and
even I,
then build up a non-formal SOP.
yes, non-formal, sir. And it is, at least in NDPS cases, of course, delay in disposal of representation, then the three grounds my learned friend has raised. Here and there it can be argued, but there are cases under
So
the
your
NSA,
learned friend has been against you in one case.
my lord.
This is the second one. If you want him to be out from the third one,
Yeah.
engage him as a special.
Yes, yes. He's already special, my lord.
I have told my learned friend, even if your lordship quash this order, I'll still be in custody. Now what happens? The operation is successful, but the patient died. This is exactly is going to happen in this case, even if it goes in my favor.
My lord, in this case also, my learned friend has raised basically three issues. One is about the delay in disposal of the representation. And second, he says that the statement of the accused and a statement that the dossier were not furnished to him. This is the second. And third, my lord, he says that while the detainee is already in custody in connection with two other cases, the cogent material based on which the satisfaction is arrived at, that is likely to be released on bail, is not there. These are the three basic contentions he has raised.
You see, the last point is a trick question. The reason is
My-
that we have section 37 in the NDPS Act,
Yes,
which is required to be complied with before the court grants bail.
yes, ma'am.
Now, despite section 37, if you say that there is likelihood of grant of bail, would otherwise mean that is the trick question. It otherwise would mean that there is nothing, no material in the case diary. So you get trapped there.
My lord.
That's why I said it's a trick question when it comes to the third point. So therefore, to build up,
My lord.
they say that cogent and reliant materials to show that there are
Likelihood.
there is a likelihood. No, there is a likelihood of him being
Released.
not released, of his being involved in the crime. Because if that is the reason, that is why you are drawing up detention order.
My lord. That's why. So far as his involvement in the crime is concerned, my lord, I will read it's the longish. I'll read the document by which the grounds were furnished, and it has, my lord, contained all the material facts and all the other materials which are available for the purpose of, my lord, coming to a satisfaction that he is required to be detained.
But there's another point.
My lord.
See, supposing if Mr. Manan is right, and the central government has not even disposed of the representation, on the ground of delay alone, we can quash it. We did not go into the other issues raised by Mr. Manan.
That is.
Because the central government, Ms. Pukan is there.
Yes.
So the central government, she is not instructed her that there is a disposal.
Yes.
So this entire matter would not take any time for the disposal. That alone is a good ground. Others may not be answered.
Till now, I do not know what is their instruction.
Central government instruction, Your Lordship, he has not annexed the representation submitted to the central government, Your Lordship. And in the prayer.
No. Ms. Pukan, that will not do. Because he says that the representation was submitted.
Yes.
It is for the central government to file an affidavit saying that there was no representation submitted. You see, annexing somebody, they are in the detention. The wife has submitted. It says that a copy has been served. You have a copy of that.
It's the restriction itself, Your Lordship, there is no prayer.
Restriction,
for
I'll
central
present it.
government,
Yes.
Your Lordship.
No. Look at this
Yes.
document.
He has not annexed the representation.
Oh, it is there. It is there. Come to page 26. It starts.
26.
It starts as page 26. It ends at page 31. Look at page 31. Serial number 2.
Only copy to is mentioned, Your Lordship.
That's a copy. You see, there's no format. Ms. Pukan, are you aware of the detention laws? There's no format. A mere postcard itself to the authority to consider the representation is enough. Somewhere in the writ petition, they have taken a ground. He's not urged it, but he's taken a ground that while in detention, the detainee wanted the help of someone to write a representation. It was denied, and therefore his wife is giving it. That is the projection. So we are not on that, but the fact remains that a copy has been served. Is itself a ground. Then you come to the next page. The affidavit of the respondent. They have given a certificate of having sent it to you. There's a direction, there's a report from the concerned authorities.
I don't have copy.
Huh?
I don't have copy.
No, that is, you see, you could have raised that issue earlier. I won't remember the pages. There's a certificate given that that this representation was duly forwarded to you. There is a certificate issued. Yes, page 68. Oh, no, this is submission. No, it's not there.
This is different.
No, this is different. This is
Only,
different.
only the confirmation order we have forwarded again to the central government as required by
Eh?
the law.
Ah,
There is at page 79.
yes. No, I had only read it.
My lord. Confirmation order.
Into 79, no,
This is
number
an intimation of the confirmation order to the central government.
Yes, I have only read it. Ah. This is service of detention order.
This is 25/7/24.
Central government have just said that they are not in receipt of this representation. That would have been the end of the matter.
Like, one,
Petition for source.
this is not one.
One.
Like,
Look
topic
at it
disposal of police only one.
নাই দিশা বুলি ক'ত কৈছে?
This I believe one of us. I letter
Copy to us.
আৰু এইটোতো আজি নোটে কেছটো ফাইল কৰা হৈছে না আজিলৈকে ডিচিশনেল ওৱান
Ah, yes. Page 6, para 6 of the rate petition. The wife of the detainee the present petitioner made a representation on behalf of her husband to so and so, so and so, and so and so.
But this paragraph 6 says copy of the representation was
Yes.
furnished to the central government. And it is there in the representation also that a copy has been furnished to central.
No, the same thing. If somebody has not received it, they will come to the court and say that this is not received.
This matter was filed in June.
Your lordship, later on
In-
only I
in
have
today.
been implemented as a central government standing on it. Previously, I was not the party, your lordship.
You
Yes.
are always
no,
the
no.
party here.
No.
Single party nothing.
Nothing. episode.
No, you see what has happened was the government advocate accepted for 1, 2, and 3.
Yes, your lordship.
The court has no way to distinguish. There is an order saying that receives on behalf of respondent for 1, 2, and 3. So that ends the matter. But in this case,
There is number 4.
Previously,
They are
I have been
respondent
made,
number
yeah.
4.
4 nothing.
Nothing.
Four.
Later on only I have been made party, your lordship.
No, 4
No.
request.
নাই নাই
always
আগত নাই পিছত আহিছে পিছত
হয়
আহিছে।
নেকি?
তোমাক engage হেৰি copy
তোমাৰ-
পিছত দিছে চাগে, but
Mark নহয়।
this was engaged.
This
প্ৰথমতে
number 4
আছে।
নাছিলে।
no, you're always there.
মোৰ প্ৰথমৰ পৰা আছে, beginning of
Petition
it.
নাছিলে।
নাছিলে নেকি
এই আছে।
You're always there. You see, we'll give you the sequence.
নাছিলে
You may not be there on the first day before the court, but the respondent was.
No, Ms. Fukan, you were there on the first date when the matter was moved. There's an order of 17/7/2024,
Yes.
when notice was issued. It says Ms. Sharma accepts notice. Miss U Sharma, government advocate, accepts notice on behalf of respondent numbers 1, 2, and 3, and Miss K Fukan, learned CGC for respondent number 4. As such, service of notice is complete in this
Yes.
case. This
Yes,
the-
I was sitting for another matter, your
Ah,
lordship.
see,
Then I have not
those-
got any copy, your lordship, before
no,
filing.
those things, you see, a long way has
Yes.
gone by.
Yes.
When when the court is recording it.
Yes.
You can't say that you were not there. Then, okay, on that day, you say that you were not aware what order was being passed, 17/7.
Yes.
Next day is the order which is incidentally passed by me in the division bench.
Yes, yes.
Y.S. Mannan, counsel for the petitioner, Ms. K. Fukan, learned CGC, representing respondent number 4 are present. List on so and so to enable the state to file an affidavit. So that day also, second day also, you are there.
Yes.
So if you are not cautious of what you have got, what you have not, it's too late in the day. So non-disposal of representation and no.
Now,
that itself
I
would
can
have-
bring instruction, your lordship, now.
No, now is the end of the matter.
One date may be given, your
Today,
lordship.
the boat has reached the destination.
But she can still find out what has happened to the representation. At least instruction she can bring as to what has happened to the representation. It was addressed to the central government. The petitioner herself sent a copy of the representation to the central government.
But he
If
should
they have
say-
not, if they have not received, or whether they have received it and they have not taken any action, because it may so happen that it was addressed to the state government. And that may be a ground for not taking into consideration. I do not know, my lord. Because it is addressed to the state government. না না এই ধরনের কপি সেন্ট্রাল গভর্নমেন্ট পাইছে এখানে অ্যাড্রেস করে স্টেট গভর্নমেন্ট
এখানে-
করব পারে কিন্তু কোনোদিন সি ক্যান টেক ইনস্ট্রাকশন ম্যান কোনো ইনস্ট্রাকশন তো নেই
Even if your
You
lordship.
can leave the court for the time being and have contact with them.
In fact, what has happened, even this annexure contains that. From June till today, she would have taken in instruction, what have you done with this?
না সি ক্যান
Okay.
still take instruction.
So because with that, we don't even enter into the merit.
Exactly. That it's because one ground is enough to.
One count is enough to cash it.
And my lord, let me be very fair. I have seen the judgment that my lord Friends was referring to at last. That is the judgment by.
Yeah.
Court of 24th of January 2024 possibly, wherein the all the materials which were discussed in the grounds of detention, my lord,
You're reading which page?
page 18, my lord,
18, 1/8
my lord,
of the writ petition.
my lord.
We are now audible.
Yes. So in this case, my lord, here also you'll find, whereas a police report of connected records have been laid before the undersigned by the Deputy Inspector General of Police STF Assam, Guwahati by this letter number so and so, 24th of January 2024, 1st of March 2024, 10th of April 2024. And then it says, my lord, third paragraph, whereas on perusal of the police report and the connected records, it appears that the said accused has persistently involved himself in the crime of illegal business of narcotic drugs since many years and was arrested in the following 3 cases. Now, whereas it is also appears from the police report that during investigation, the seized particulars suspected to be heroin in respect of aforementioned cases were sent to FSL for examination and FSL report indicated positive tests for heroin. Whereas as intimated by Deputy Inspector General of Police STF Assam by this letter number so and so dated 24th of January, that the accused has been found to be a repeat offender under various sections of NDPS Act 1985 and his detention under PIT NDPS Act is imperative to keep him out of business of illicit trafficking in narcotic drugs and psychotropic substances and break the network of drug supply in the districts of Kamrup. And then the satisfaction was mentioned. Now, Lordship may kindly see the grounds of detention supplied to him at page 21. The materials which were considered to arrive at the satisfaction that he is required to be detained. Para 3, which my learned friend also has read. My lord, the heroin weighing about 1.873 kg was recovered from his vehicle. However, you managed to escape from the spot on your Hyundai car, Creta car, bearing registration number so-and-so. Later on, during your period of absconding in connection with STF PS case number so-and-so, under section so-and-so of the NDPS Act 1985, you were apprehended and arrested on 11/9/2023 by North Guwahati Police Station for committing similar offences under NDPS Act. This refers to North Guwahati PS case number so-and-so under section 21C and 29 of NDPS Act 1985. Thereafter, you were arrested on 22/9/2023 by STF in connection with STF case number so-and-so. Now, during investigation, you and Mofizul Haq were arrested, and after proper interrogation, it was found that you and Mofizul Haq were involved in peddling of drugs all over the places in Guwahati city and in other areas of Kamrup district. This refers to STPF PS case number so-and-so. The next page, again, my lord, in respect of the Gitanagar PS case. Further, prior to the above referred STPS case number 6, you were also involved in other offences of NDPS. On 12/6/21, based on confidential input regarding the presence of drug peddlers at house number so-and-so, Rupali Path, RGB Road, an operation was carried out the same day at 10:15 p.m. by Gitanagar Police Station to nab the drug peddlers. During the search operation carried out in the said premise, 2 drug peddlers, namely Bhargav Giri, alias Bablu, and Sri Mrigan Bongjan, were found inside the rented house and as such were apprehended accordingly. During search, suspected heroin drugs amounting to rupees 15.75 grams without plastic container and another 42.75 grams in plastic container were recovered and seized from the accused persons. Moreover, based on the statements of the said accused persons, heroin drugs amounting to 213.75 grams and with container and 65.45 grams without container were recovered and seized from the rented house shared by you with one Motiur Rahman at the house number so-and-so, Sabun Factory, Guwahati, Gandhi Basti. Motiur Rahman was the then apprehended from this house, number 2, village under Sipajar PS, Darang district. Thereafter, during search in your house, in the village of Loch under Baihata Sariali, more suspected heroin drugs amounted to 73 grams with container, 8.65 grams without container, cash amount of 3,88,150 and one I-20 car were recovered and seized from your possession. Moreover, during another search carried out in the house of one of your accomplices, namely Asik Ali, in Bildia Belkona village under Baihata Sariali, Kamrup district, more suspected heroin drugs amounting to 775 grams with container and 250 grams without container were recovered and seized from his possession. In this regard, a case case was registered by the Gitanagar PS case number so-and-so under section 22C and 29 NDPS Act 1985 against you and your accomplices. Sufficient evidences were obtained against you and your accomplices of being involved in illegal drug trade, and as such you were arrested and forwarded to judicial custody along with the other accomplices. And as far as the documents are concerned, in all the 3 cases, my lord, down below it has been mentioned that the photocopy of FIR, GD extract, seizure memo, FSL report, and counterfoil of CS are annexed herewith and marked as annexure so-and-so. So all these in respect of all the 3 cases were duly supplied to him. So this submission that all the documents were not supplied to him possibly may not hold good. Delay, my lord, as I have seen, this is the stand taken. If your lordship goes to my affidavit, my lord, lordship may kindly see. Ultimately, we have relied on para 4 and 14 of our affidavit, saying when we were replying, my lord, para 15 at page 49, we say that with regard to the statement when paragraph 17, because it was 17.
Just a moment, you are reading where?
I am reading from page 49, my lord, of my affidavit in opposition. Because what has happened is my learned friend has in the writ petition taken a plea of non-disposal and non-consideration of the representation in paragraph 12. Paragraph 12 particularly. Lordship may kindly see paragraph 12 of the writ petition where my the writ petitioner has raised the question of
Seen that.
my lord. Now this was replied to in paragraph 12 of our affidavit in opposition at page 45,
Yes.
47. And there we have said we are affirming the statement made in paragraph 7 of our affidavit.
And it's
That your lordship will find in page 41.
page 41, yes.
41 we have said, this is the plea we have taken, my lord. The deponent begs to state that representation of the petition dated 30th of May 2024 addressed to the Principal Secretary Home and Political Department has been received and is presently under due consideration for its disposal. In the meanwhile, the opinion of the Advisory Board PIT NDPS Act 1988 has been received by their letter number so dated 7/7/24 mentioning that there are sufficient grounds for detention of the petitioner's husband. And then in paragraph 14, as a sequel, after paragraph 17, my lordship may see paragraph 14 at page 48.
Just a moment.
My lord. Yes, so what I was saying is, my lord, in para 7 of page 41, we have mentioned that advisory board's opinion was received on 7/7/24. And while annexing the opinion of the advisory board, my lord, we have also annexed the copy of the order by which the representation was rejected. And because that is on consideration of the opinion of the advisory board. So that is the position, my lord, with regard to his contention that there was a delay in the disposal of the representation. It was disposed of, but on 3rd of August 2024. It was considered and disposed of.
Therefore, only legal point remains, we take it up next Tuesday, that factual aspects, these are the
My lord,
submissions.
yes.
Mr. Manan, Tuesday next.
I have completed this.
Unless you waive a right for waiver, for reply.
Not required, Your Lordship. In fact, what I have stated, even if something comes up, if it is whatever is on record that I have.
Heard. Mr. Y.S. Manan, Leonard, counsel for the petitioner. His submissions are completed. Comma, reserving right to reply. That's correct. Next one, the submissions of Mr. D. Mazumdar, senior counsel, assisted by
D.
D.
Devi.
Devi,
Devi.
Leonard counsel. remains inconclusive. First of list again on 10/12/2024 for the hearing.
My lord, in place of 10, can it be 12, my lord?
No, 12th you have already
12,
fixed matters.
Even I am not available on 12th,
Uh,
12th and 13th.
Your matter is there
Our matter is also there.
on 12th.
Ah.
See, so you take a choice, have a toss and
Oh,
elect. You want this or that.
My lord,
You fix your matter.
considering this side, my lord, in both the cases, it's same now, it appears. My lord, can it be on 19th then? Of course, it will be
No,
just.
that will be too
I'll
inconvenient.
I'll take only half an hour, my lord.
No, it's not a
I-
question of time now because it is very difficult to manage during the last week of
Yes,
the court
that is
week.
correct.
Even you.
Or can it be on Monday, my lord, 9th? I'll take only half an hour, my lord. Only half an hour.
9th.
Yes, yes.
Okay.
I'll take only half
Make
an
it
hour.
9th. 9th.
Well, I'll deep down.
The time limit of half an hour is recorded.
I'll be very brief, my lord. Your
No,
lordship
no,
has seen in the
not that.
facts of the case, possibly I'll have very.
No. Nothing with nothing, no interpretation about it. Your submission is recorded. That's
And it will remain. It will remain
It is also recorded here. You.
for
I can
posterity.
point it out.
And Tuesday, actually, I have got some difficulty in second half. In the first half, your lordship gives me
We
some
don't
time.
know. We don't know.
That is
This
why.
list
Let
is
it be on Monday,
unpredictable.
anytime I can do it.
List
Subject-
is unpredictable.
As per your lordship's convenience, I'll do it whenever your lordship
List
find
is
it.
unpredictable.
Deeply okay.
Obliged.
Item 22 of the sublay list.
You've gone through the records.
Yes, sir.
Yes. Okay. Good. The LVO report. Yes, Lord. It doesn't say that he's a illegal migrant.
Lordship.
Eh,
But that, there is a ERO's report, Lordship. Why on then inquiry was made by the ERO, Lordship? ERO report is there, Lordship. That was next, not annexed in the petition. That was not annexed in the petition, Lordship. On the basis of ERO's report, Lordship, matter was forwarded to concerned foreigners tribunal, Lordship.
Correct, the ERO report doesn't say that is a foreigner. We have seen on that day,
Yes,
the ERO report,
Lordship.
it doesn't say that the petitioner is a foreigner.
No, Lordship, may I kindly?
I just.
May I read, Lordship? Yes. Whereas the Election Commission of India has ordered intensive revision of electoral roll for the 45 Gakbor LSC in Assam with reference to 1197 as qualifying date. And whereas house to house enumeration was done during the period from 16 January 1997 to 15th April 1997. Whereas the name of Sri Kadir Paramanik, son of Makbar Ali, who has declared an Indian citizen and also an ordinary resident of Satra Kannada, G Reserve, has been enumerated for inclusion in draft electoral roll. And whereas the electoral roll of the said constituency has published in draft on 24/7/1997, including therein the name of the said Sri Kadar Paramanik, and whereas I, the electoral registration officer for the said assembly constituency, having doubt about the citizenship of the said person, got the matter verified by an on the spot local verification, and whereas on consideration the report of such verification, I have reasonable doubt that he is not a citizen of India.
Next page is that report.
Now, therefore, the matter is forwarded to.
You forget next things. You come to next page.
Yes, Lordship.
That is LUO report.
Yes, Lordship.
Page 1, there is nothing.
Yes, name Kadir Paramanik, address Satra Kannada, G Reserve. Mother's name is not given. Father's name Makbur Ali. Date of birth 1960.
There is nothing in this page suggesting he is a foreigner. Correct. Come to next page. Same thing.
Yes, Lordship.
No
It-
suggestion that he is a foreigner. His mother tongue is Assamese.
Yes, Lordship.
That is the brilliant person you have sent. He's saying that his name is Paramanik and the language mother tongue is Assamese. I come to next page again. Nothing. Not even a whisper that he's from Bangladesh.
Yes, Lordship. What they have stated, Lordship, that was ventilated in the LBO's report, Lordship. And nobody.
A says I refer to the B's report. B says nothing.
Lordship, my humble submission is that, Lordship, nobody will say, Lordship, I am coming from Bangladesh, Lordship.
No, that's not required.
Yes,
But
Lordship.
what is the satisfaction of the LVO that he is from Bangladesh?
On the contrary, Your Lordship.
He could have said that no disclosure is made. Therefore, I suspect him to be a Bangladeshi. That's the end of the matter.
On the contrary, at
In
the
place
local-
of birth, date of birth nil, Lordship, date of issue nil, certificate, extract copy of electoral roll 1966, Lordship. That was placed, Lordship, before the LVO, Lordship.
We'll
And
have to rise.
but
We'll have to rise. We'll take up some other day. Other matters would be adjourned.
Kindly give me bail. I'm in jail. Kindly give me bail. Let it be fixed. Any day, Your Lordship desires. I've been detention for last 3 months. I've been suffering.
is this aspect was done by this honorable court, Lordship, in Sam Uddin's case, Lordship. WBC 91/2019.
What does it say?
Lordship. In the para 11 onwards, Lordship, in the year of 1997, Election Commission of India had undertaken an intensive revision of electoral rules in the state of Assam, as apprehensions were expressed from various quarters that the electoral rules were infested with the names of foreigners, illegal migrants. In the course of this exercise, citizenship status of as many as 3,13,046 persons whose names were in the draft voter list were found to be doubtful, and accordingly they were marked as doubtful the voters in the electoral rolls after local verification. Legality of this exercise was challenged before this honorable court in HRS Chaudhary versus Election Commission of India, reported in 2002 1 GLT 1. This challenge made was rejected by division bench of this court. In HRS Chaudhary Supra, this court examined the guidelines dated 17/7/1997 of Election Commission of India, laying down the procedure to carry out the exercise. 12.1, as per paragraph 3.8 of the guidelines of the electoral registration officer, was required to consider the verification report received from the local verification officer. If he was satisfied on such report and such other material information as may be available about the eligibility of a person, he should allow his name to continue on the electoral roll. Where, however, he was not so satisfied and had reasonable doubt about the citizenship of any person, he was required to refer such doubtful cases to the competent authority under the then IMDT Illegal Migrants Determination Tribunals Act 1983 of the Foreigners Act or the Foreigners Act 1946, as the case may be. For convenience of the electoral registration officer, Election Commission devised pro formas. Lordship, their guidelines also quoted, Lordship, in this area.
This judgment was
judgment.
actually in my favor.
Don't interject. Somebody is making an argument. Don't start a parallel argument.
As
Something
per
I strongly dislike.
as per paragraph 3.9, after the case of a
Now,
person.
see, in that paragraph you were reading,
Yes, Lordship.
you see that is satisfied.
Yes, Lordship.
So where is that satisfaction? Either by the LVO
Lordship.
or satisfaction of the review. Otherwise, they would have, you see here it says,
Yes.
if it's not satisfied, then he'll give a, what do you call, rejecting, he would have rejected that. The LVO report is rejected. I find from the lack of materials in the LVO report that he's a foreigner. He says on the basis of LVO report, I declare him, suspect him to be a foreigner.
Lordship.
Therefore, we have to come back to that LVO report. Where is that?
And Then Lordship, I
Other
will apprise
paragraphs-
your Lordship, I will
Other,
apprise your
other,
Lordship.
other paragraphs will have no meaning after that.
Hmm. But
This judgment is not an authority that if the LVO report says nothing and the, what you call the ERO
yes, Lord.
refers to it, it will still mean that this, the ground of suspicion is
Yes,
valid.
Lordship. They may have some doubt, Lordship, ERO Lordship. That's why he forwarded the matter to concerned foreigners tribunal, Lordship. And before the tribunal, he is getting enough scope, Lordship, to prove his case, Lordship.
You show us, we have the decisions, you know about the decision, you have to satisfy us on that.
Yes, Lordship. I will satisfy, Lordship.
Positive time,
Bail may be. So bail may be considered. The IA.
You file an IA?
Yes, you.
Where is that IA?
Your Lordship, we are also submitting two judgments, may go through if whenever your Lordship desires.
There was no pleading at all, Lordship. He contested the case, Lordship.
The man is for 4 months.
Yes,
in,
Lordship.
The detention. Right. D. Agarwal, when it comes to the petitioner, applicant. Also heard. D. Sharma and CNC appearing for respondent number 1. Stage Kuli on behalf of US AIRE standing counsel for respondent number 2. Mr. G. Sharma, standing counsel for the active matters representing respondent number 3,
5 and 6.
5 and 6. Mr. R. Talukdar, Learned Government Advocate appearing for respondent number 4. Next paragraph. By this interlocutory application, or the applicant, namely Kadir Paramanik, who is the petitioner is in the connected writ petition, seeking release from the transit camp from Mathia, Walpara. Where he is presently detained since his arrest on 7/8/2024, pursuant to the opinion dated 15/11/2021, passed by the learned member of Foreigners Tribunal number 4th of Barpeta in FT case number 78 of 2018, arising out of I am within bracket D, bracket post T, case number 7703 of 98, by which the applicant was declared to be a foreigner of post 25/3/1971 stream. Next paragraph. Pursuant to order dated 11/11/2024, passed by this court in the connected writ petition. Now the records of the tribunal was called for. Most of the same is received. Most of there is the same for the purpose of considering this interlocutory application for bail. Next para. The materials available in the case records requires further examination. Next para. As the on a consideration that the applicant was detained, apprehended and detained since 7/8/2024. And he's in, and since then he's in detention for about 4 months. The court is of the considered opinion that the applicant be released on bail on the following conditions. Next para. You take the format from Chamba. It will start like that. The applicant, the family members of the applicant shall appear before the Superintendent of Police within bracket border, bracket closed, Borpeta, and furnish bail bond of rupees 5,000 with one surety of like amount. And also produce a certified copy of this order. Next para. Within 3 days of the production of the certified copy of the order and furnishing of bail, the Superintendent of Police shall take steps to take the applicant, namely Kadir Paramanik, into his custody and then record his iris of the eyes, both the eyes, fingerprints. Those conditions will also get, another condition is that you take the necessary undertaking. Let's see that. Thereafter the petitioner shall be allowed to go on bail. Next, as a condition for bail, it is provided that the petitioner shall not leave the territorial jurisdiction of the Superintendent of Police within bracket border, it was Borpeta, without prior written intimation. Failing which it would be open to the said authority to move this court for cancellation of bail. Next para. Application stands allowed and disposed of.
Grateful.
You just said there that the learned standing counsel for the FT matters has opposed the prayer for bail. But that will come, that since he's in custody for 4 months, that can be.